Welcome to the Foul Play YouTube channel.
Hello, everyone. Welcome to episode number 29 of the Open Mic. After our week of having a big old gut punch from the Court of Appeals, it's time to get back up off the mat and keep on trucking and not stopping, staying on this train. I am. So, going through it, just been thinking about it quite a bit. A lot about what was said and a lot of things that they brought up, given the her 974.06. Today, I've decided to go back in time to 2013 and take a look at Avery's pro se motion and just go through some of the highlights of some of the things that he had in his pro se motion that she had dismissed. But before we get rolling, let's let everyone just go down the list. You can see yourself there in Discord. Say hello to everyone. Alice?
Hello, everyone. Hello, everyone in chat. Thanks for coming.
Becca?
Howdy, howdy.
Hey, hello, everybody.
I have no idea where I'm at, so rock on, soldiers.
Peeks in.
Sammy.
Hi there, how are you?
Okay, good. Okay, well, what I'm going to do, I'm going to, if there's any questions, guys, put it in the chat. Sammy and the gang, someone will generally pick it up and we'll try to answer any questions that you might have. But let me get this PDF file pulled up here. If we look at Avery's pro se motion again, I've highlighted quite a bit in here because I was just doodling around and just reading through because I like I said, I got pretty aggravated like everyone else. It was a pretty harsh hit, but I can't say it was totally expected, but I can't really say it was totally unexpected given what we know of what's been, or really what's happened since Zellner took the case. Everything's been denied. And, she dealt with Tom Fallon, as her first contact originally. Everybody knows how I feel about that. I think that was a big old setup. Mr. Fallon, he's a very intelligent man, and I think he used his knowledge and good graces and position as an AEG within the state, to hoodwink basically Zellner, but she took him at face value and at his word. And I think that there was some hoodwinking that went on there about various things, but that's a discussion for another day. Anyway, let's take a look at this Avery's 974.06 motion that he filed in February 14, 2013. And I'll just read a little bit of it here. And I won't read all of it. Again, I've highlighted quite a bit. I'm not going to read everything that I highlighted because we'll be here all night. And that's not my intent. My intention with reading this is because the Court of Appeals mentioned this pro se motion and Zellner dismissing this one so she could re-enter a new one, which was filed in 2017. So Avery requests an evidentiary hearing on this motion and that he be allowed to appear in person or by telephone for this hearing. So he's right there, way back in 2013. He wants an evidentiary hearing. So statement of the case and facts, October 31st, Reese Halbach, there here and after Halbach, at or near his home to have a vehicle his sister wanted to sell, photographed for Auto Trader magazine. On November 3rd, 2005, Karen Halbach, Halbach's mother, contacted the Calumet County Sheriff's Department. Karen Halbach stated that Halbach had not seen or heard from since October 31st. Karen Halbach said it was unusual for her daughter not to have had personal or telephone contact with her family or friends for this length of time. Karen Halbach stated that her daughter was driving a 1999 Toyota RAV4 dark blue in color. November 4th, 2005, MTSO County Sheriff's Department interviewed Avery at his home. Avery candidly answered questions and allowed the investigators to search his residence. November 5, 2005, the Manitowoc County Sheriff's Department requested CASO Sheriff's Department a lead investigation on behalf of MTSO under the doctrine of mutual aid. This was because Avery had a $36 million lawsuit against MTSO, Manitowoc County, for having previously put Avery in prison illegally. On November 5, 2005, officers received information from volunteer searchers that they had located a vehicle matching the description of the vehicle owned by Halbach at the Avery Auto Salvage Yard. The volunteers were able to gain access to the property through an employee of Avery Auto Salvage. The volunteers provided a partial description of the vehicle VIN number. Taking this as confirmation that Halbach's vehicle was on the property, Calumet County investigators entered ASY without a warrant and began to investigate. Avery's curtilage is located adjacent to the Avery Auto Salvage property. So he goes on and he describes, in some detail. I'm not going to say he got every single thing correct, but I guess it's as close one way here or another. But he got the main points in. Because he does talk about later in this his motion about the search warrant. So he goes on to say, they got a tow truck in or an issue to search the Avery tow truck belonging to the salvage yard. Then he talks about the state charged Avery with first degree intentional homicide, mutilation of corpse, felon in possession of a firearm. He talks about that a little bit later too. The charges related to the October 31st, 2005 of Halbach. You can also tell by going through this that he wrote a lot of this. He made a lot of errors. You can tell that it wasn't written by a lawyer at all. I give him chops. I don't know that I could write it. Given the complexity of any state law, it's not easy to do. And there are a lot of things that he does, a lot of cases he cites. So I got to give him a little credit for that, considering. While being housed at the Calumet County Jail, Avery met with the attorneys and his private investigator. The jail engaged in active monitoring of his conversations with his attorneys and investigator. See Exhibits 1, 2, and 3. His attorneys never challenged the information provided in Exhibit 1, and I don't have Exhibit 1. I apologize for that. However, Avery only found out about the monitoring by 4 jail workers through an open records request after his conviction was final. We've talked about that before, too. After nearly 5 weeks of trial testimony, the case was submitted to the jury. At that point, the jurors had been sequestered just one day. The court retained the remaining alternate juror and ordered her sequestered separate from the deliberating jurors. He goes on and talks about that whole thing with Richard Mahler. He had to leave, and then come to find out his daughter wasn't really in a car wreck, or it was just a fender bender. It was all this minor stuff. So, and then talk about replacing. Let's skip forward a little bit more. There's quite a bit to talk about tonight. Here's another argument. Avery was denied his rights under Article 1, Section 7 of the Wisconsin Constitution and 6th Amendment to the United States Constitution Council. The right to confer in private. Now, we've had many discussions, but I'm not going to talk about all this down here. I didn't highlight it either, because he cites a lot of cases about where it's illegal to monitor conversations between an attorney and his client. I'm not going to discuss all that. Before I move forward, though, any questions about what I've just kind of breezed through there? This was just the beginning of his motion, and some of the things he goes on. He lists more things here. That's just the beginning. But any questions, comments, concerns? Anyone? No.
I'm really seeing is a discussion about, the phone call that Karen made, described in the RAV and the color, and all that. Pretty much it. Okay. All right. Well, we can move on and talk a little bit more about this. He's talking about the right to confer in private. Now, we've had many discussions about that, and this is a little bit later, and I didn't include it with this, what we're going to talk about tonight, but I've talked about it before.
I've talked about it with Linda. We had a really good podcast about that on her channel. How long ago was that?
Yeah.
Well, that was last year, wasn't it, Linda?
Yeah, but it was 2 parts.
Yeah.
I think. So
Yeah.
it was really, really good. Yeah.
And, you know, we dove into the aspect that Avery, as he said here, he found out about the surveillance after he was convicted through 4 jail workers, and he FOIA'd some information, got FOIA'd, and then I don't know exactly what's in that FOIA. Hopefully at some point to find out. I've not got that far yet, but nonetheless, he found out about this surveillance. I'm guessing this installed camera that was in the privacy room, and it's not supposed to be there. Even the jailer, John Burns, he was the jailer of Calumet County. He said there's no recording devices in these rooms. Or I think there's 2. I thought originally there were 4, but now I went back and reread some other things. I'm almost positive there's 2 of these privacy rooms where, you know, lawyers, you know, even cops, clergy, counselors can come in and talk to a defendant, or maybe even someone that could be serving a short jail sentence at the Calumet County Jail. And I know they're not very big, so they couldn't do much of that. So anyway, he talks about the legal standard. As you can see, I'm just going to kind of scroll through here. We get down to another section. You can see all the things he cites in there. It's really pretty thick reading. I'm going to guess he has someone helping with that. And then he talks about the balancing test where the right to a private consultation is infringed upon, which was good that, you know, that got included. I'm guessing that someone helped him with that, including him in, that he needed to include that in his motion. And we get on down here. Where are we going to? Then he talks about fashioning a remedy. And it says here, it is fortunate in this instance, Wisconsin case law contains a reference to one of the most cited cases, gives guidance on the issue of remedy. And it is a concurrence of State v. Hoyt. And Justice Gordon restates the guiding words. And I'm going to read a little bit of it. I'm going to read it all. There is no way to isolate the prejudice resulting from an eavesdropping activity such as this. If the prosecution gained information which aided in the preparation of its case, that information would be as available as in the second trial as it is in the first. And I've talked about that before, and it's true. That information is still there. Nothing's changed, right? So he did include that. So let's move on to the next section I wanted to talk about.
Credit. You know, he's got a lot of statutes in there, so I give him a lot of credit for that.
Oh, he cites a lot of cases, and
yes, he does.
I give him credence for somebody. I'm sure somebody helped him, but you know, he still had to write it. Anyway, his argument: Avery's defense team included attorneys String and Buting and investigator Bass. Any discussions with these persons were protected by the oldest legal privilege known to American law, the attorney-client privilege. However, far more importantly, the Sixth Amendment protects any discussions concerning strategy. The Sixth Amendment right to counsel includes the right to private consultation. Moreover, the denial of that right is a denial of the right to counsel, a structural defect that is not subject to harmless error analysis. So I thought that was a really good argument that he put in there, and it's correct. There's been a lot of discussion about the tape that, or the recording that Kratz revealed and included before he hauled ass off of social media that showed Buting, or showed Stephen with I think it's Buting. I can't remember, but nonetheless, it's a video only, no audio. But to me, it's just almost idiocy to think that they would have a camera in there and not have a microphone attached to it. I'll always believe it until somebody disproves that. That's my belief. I'm not asking anyone else to believe that, but that's my belief. There was audio with it.
I believe it, Jax. And also, how would the prosecution like it if they were listened to? Reverse that situation, see what they would think of that.
Well, exactly. But if you think about they're going to use it for monitoring, well, that would detail that somebody would literally have to be standing beside a monitor somewhere.
Yeah.
Yeah,
And
that's exactly what they were doing, Jack. They were watching all his visits, they were listening to all his phone calls, and I guarantee you the camera that was in that room had a mic on it so
No
that
doubt.
they could listen in.
No doubt.
And just remember, we were wondering, were they monitoring him for a long time? That was a question we had. Obviously, they were.
I think from day one. I think before day one. I think that as soon as he is, Glenn and Kelly filed the civil suit, he put a target right on his forehead.
Yeah, but not only that, Jack. I mean, you just take the phone calls of Brendan and Stephen from the very beginning for the first one and until later on. Their phone calls were about an hour long. And because they were listening in, because they were trying to catch them out. They were trying to see if they were going to spill anything or slip anything up or anything that they could use or find out so that they could find a way to use like they did with Brendan. And that's my opinion.
Well, look what they did to how they handled that. Just think about this, Alice, and I know you probably know this. In the conversations, Brendan was constantly trying to get all of his friend Travis. Well, he wasn't really a friend. Brendan thought he was a friend, but to me, he was just nothing but a dick, complete dick. So then what happened out of those conversations? Wiegert and Fassbender went and told Barb and the family that Brendan was a crack addict and crackhead, that him and Travis were, dealing drugs and doing drugs and all this crap. And it was a lie. Told them that they had blood tested Brendan and they found he was doing crack and they knew it. It was nothing but a lie. And why would they do that? So that tells you right there, they were listening to these phone calls that Brendan was having with everyone.
Yep. And they were doing exactly the same with Stephen. If no more with Stephen than they were with Brendan. Because as I says, the length of the phone calls at the beginning, you didn't get the wee wifey coming in and going, you have 2 minutes left. It was always, your call is being recorded, So they were listening in, and then as time went on, they realised that they were getting sweet Effie, and that's when they started lessening the hours of the calls and the times of the calls. That's what I think.
Well, I mean, I know that Stephen had, I'm not sure what he had, but I'm pretty sure they just give him. Well, they just gave him a phone, basically, I think, at some point, because some of his calls are longer than 15 minutes. Now, as far as I know, that I can remember, none of Brendan's calls were over 15 minutes. In fact, they gave him such a hard time about his calling cards that Barb and the family had purchased for him, and even trying to get his calling cards so he didn't have to call home collect all the time. That was really a struggle in the beginning. And then it's just a big old ripoff, though, because I think 15 minutes costs something like, I can't remember what it is now. I don't want to say it wrong. Seeming like 15 minutes was $20 or $25, something like that.
It was like $1 something a call, $1.80 something or 90 something a call. It was ridiculous.
Yeah, it's just absolutely dumb how expensive it was.
A minute,
not a call.
Yes.
Yeah.
Yeah, I meant a minute. Sorry.
What a ripoff, right? I mean, it's good work, I guess, if you can get it. But man, you're ripping these prisoners, these families, these prisoners off. I get it. They're prisoners. They have no rights now. This 13th Amendment. But at that point in time, Brendan had been convicted of anything, right? So you're treating him as someone that is really been convicted, because you're forcing the same rules that you would force on someone that's convicted. Even in these state prisons, calling is expensive. So anyway, I don't want to belabor that too much more. Anyway, this argument about being monitored and surveilled, I think was a good. He needed more merit with his motion here. He's just, for him to just say it is not enough. He had a little bit with his FOIA, but he really needed access to an investigator, an honest investigator, somebody that would bulldog it and find out exactly what they did. Because we found out, Judge Suckowitz did appoint an investigator. He got stonewalled, and basically at every turn, he goes back and tells her, "Oh, there's no surveillance, but here's my, $5,000 bill. I need to get paid for this, please, thanks. And so she had to rule there was no evidence of any kind of surveillance at the jail, but in fact there was. So anyway, this.
And what are the chances that Judge Suck at this maybe slipped a little idea to the investigator saying, don't worry about trying too hard to figure this out?
It's possible. It's very possible because, she'd been dealing with, the civil suit that the Hallbox filed. She was part of that, which I can't, I'm not really a lawyer enough to say that should have disqualified her, but I don't know, Sappercroft. To me, it almost, she should have just said, you know what? I need to step away from this and recuse myself. This needs to go to another judge because of that.
Well, that should have been automatic. The chief judge of the court should have pulled her off, seeing the conflict of interest there, and the fact that they didn't is alarming.
Yeah, I think so too.
Not surprising though. I mean, come on, look at the whole investigation. MTSO was everywhere. They were all over it. They found key in evidence. They don't believe in conflict of interest.
No, except for the county coroner, which had no conflict of interest at all. So anyway, a little bit more here. Now again, you have to understand, Avery didn't have what he needed to back up his claim here. He was definitely onto something, but he couldn't prove it to the court. But anyway, let's move forward. The jail monitored the conversation between Avery and his defense team, creating a chilling effect on communications on July 20, 2006. In the present case, Avery and Bias had been warned by a jail worker on July 20th, 2006 that they were being recorded. That this act alone had a chilling effect on Avery's Sixth Amendment rights. Avery was unable to offer full and frank information and could not be probed by his investigator for pertinent information that would or could have aided Avery's investigative efforts. Exhibit 1 is a memorandum that existed in Avery's attorney's control. I do have that memorandum, but I don't have it pulled up right now. I've got it though. Remember, Linda, I pulled that up. That's the memo that Bias wrote and talked about all of this shit.
Yep, Strickland now.
Okay.
I got it.
Anyway, indeed, the failure to seek out evidence of other recordings or obtain the recording of this conversation was improper on the part of Avery's defense. So he's saying that in July of 2006, String and Buting should have known because they were told by their investigator, hey, they're recording you guys at the jail. You have to watch what you say. And then for them to take that to whatever direction needed to go, to the judge, to Willis or whoever, someone that could properly investigate this on the. Now, who's to say where that would have went? I'm not even going to go there right now because that requires some pretty big speculative leaps there. So anyway, B, the state was continuously monitoring Avery's protected conversations with his defense team. There's evidence that the statement made on July 20, 2006 was not mere threat or bluster on the part of his jail worker. After his conviction, Avery was able to obtain through an open records request 2 documents that may have been discoverable, but it is certain that the state didn't furnish them to Avery based on his discovery request, and that would seem to end any requirement to investigate their existence on the part of Avery or his legal team. Indeed, the recordings of privileged attorney-client conversations violates the privilege under both federal and Wisconsin law, but as noted above, where the Sixth Amendment is involved, the state has an affirmative obligation to protect Avery's rights. It would be unreasonable to think his protected conversations were being observed, much less in content in any way being relayed to the prosecution and the prosecution. What exhibits 2 and 3 show is that 4 officers did just that. On March 17, 2007, they proved that the warning given by us was far from passing remark, innocuous or otherwise. Further, these 2 incidents show a pattern of monitoring which many of Calumet County's jail workers were aware. So, he goes on again. I'm not going to read every bit of this. This is this is a whole nother subject in and of itself. I know people can agree or disagree. It is a little bit subjective, but there's definitely something there. We've seen the recording, we've seen the video, so we know there's probably a lot more that we've never seen and may never get to see, but time will tell. Anyway, let's move on. Unless there's questions, comments about the surveillance, because to me it's a real sticking point for me. I have a real problem with it.
Well, it just seems like everybody's in agreement with some of the opinions, so we're looking good.
I think honestly that, I mean, for Stephen to bring this up, and even though he's not a lawyer, I mean, he brings it up in a good way. I don't know if it was enough meat for that book to say anything about it, but kudos to him.
But then Buting claimed he had no knowledge at all that this was happening.
Well, unless he read Stephen's motion, he wouldn't, because we didn't find out until Kratz did it.
But see, the problem is Pete Bites' memo.
Oh,
They did know.
So he did know. Well,
yeah, he
I believe Mr. Buting anymore then.
Well, yeah, I mean, that memo was clear. I wish I'd have pulled it up. I've got it.
Could it not have just been a fact that they were inundated with emails and information? And because you've got to remember, they were only 10 months on the case.
When your investigator's giving you a memo, though, or an email, you should look at that. So that really just kind of makes me wonder. I mean, a little slighted.
Well, I think it was a mistake. I mean, there's so many things that were on their plate, I'm sure, and they had to pick and choose. No doubt. You're right, Alice. They did. Because it was only him and them two lawyers. And then Buting's wife, I think, helped out. And I think they had a couple of paralegals that were maybe even part-time.
Yeah, but if you have an investigator who's looking into things, you want to pay attention to his emails. I find that kind of a rookie mistake. I don't think that would be bombarded with emails. You go through them, you see who's sending it. You want to look at your investigator. That's my opinion, anyway.
Oh, I'm not saying that they didn't. They very well may have. I'm just saying that they knew. I'm sure that they were aware of what possibly they could be facing. Maybe I don't know. I can't answer that.
To me, they had a shitload of documents to go through. You don't know what size this file is that their investigators handed over. They've maybe just whisked through it, went, no, that's not going to help, that's not going to help, that's not going to help. And it just might have been something that is just being slipped, which is fair enough, you know what I mean? They had over a year's worth of case papers.
I tend to agree with you, Alice.
To look through.
Agree with you.
Yeah, they were only on it 10 months. You imagine a year's worth of documents between motions and filings and denials and everything like that. So they had a shitload of documents to go through.
Think about,
so it could have been something that was easily missed.
Think about,
Well, can I say one more thing? You look at the stuff we do get when we get stuff and how it's handed over. I mean, come on.
Well, forget the fact that it was a memo, a written document. You're telling me an investigator like Pete would not have gotten some information like that and went and told them verbally, hey, guys, you need to watch yourselves. You're being recorded.
I would imagine he did. I can't remember what the memo said. Maybe I'll look here in a minute. If we get into the conversation, you guys can talk, and I'll see if I can find it. Because I was looking through some things earlier yesterday and today to go along for today, and I remember reading this part of the pro se motion I'm reading, but I didn't pull it up. But anyway, you may be right in this, Alice. We have to remember this is July 2006, and I can't remember. I think it was String that came on first towards the end of February. He wasn't really involved quite yet, but he was there. And then Buting came on about a week later, I think. And then all of a sudden, bam, Brendan's arrested. Kratz gives a press conference. You got all this other stuff going on. And I don't disagree, Linda. I think they should have jumped all over it. But that said,
yeah,
pick your battles. Well, pick your, yeah.
That's kind of a big battle, though, Jax. You know,
I agree.
mean,
I don't disagree.
yeah,
I
yeah.
think it's a pretty huge thing because they, if there's any hint of them
Total
being
invasion of his
privacy,
privacy, of his
yeah.
of his. It is. To me, it's a big. It bothers me as much as it does you. So for me, for them to overlook that, that's really a bother for me.
I've got to
Well,
say,
you have to.
go ahead.
I was gonna say you have to look at the depth of that issue. I mean that's no small thing.
Yeah.
Violating the attorney-client privilege, because even worse on that is that means the prosecution is or possibly potentially gathering all of your defense plan, right?
Thank
That
you.
destroys your whole case.
Yes, thank you. I think it's a very big deal that they did not. I mean, I didn't know that they had the investigator. For some reason, that just went out of my head. But this, to me, is really bothersome. Maybe that's why some people say that Buting and Strain didn't do a great job. I mean, that could be their opinion.
I think it's.
I mean, I'm not saying that you're no right, Linda, but I mean, I'm trying to look at a different angle. You know, the amount of stuff that they had to go through, and if he's just went and says to them, "Oh, here, by the way, you're being monitored," and no, that could mean anything. That could mean the calls. So they might have been right. Oh, we're being monitored on the calls, so we'll watch what we're saying on the calls. Being monitored, just saying being monitored, that's not meaning that you're being videoed or not.
Oh
So
no!
when that,
No,
when
the information was that they were being monitored at the jail.
Yeah. Now, Alice, I don't care. I would take my investigators' emails, or our communications would be first if I hired an investigator to be looking at this. No matter what they're looking at, I would be looking at what my investigator is telling me. That is too important. As far as, in my opinion, it's a big F up right there.
Oh, is it?
And Crockett's asking, do we have the Pete Bates memo?
Yeah, I'm going to pull it up here in a minute. I've got it.
I'm pretty sure Pete would have been more specific than just saying being monitored. He would have told them specifically how they were being monitored and by whom.
Right, because remember him. He had a lot to say about their, the search warrants. I mean, for Christ's sakes, you don't do that, and we know you do not. You're not kicked off your property during a search warrant. You're not being able to have as many days as you want on it. That's kind of stuff that just only happens in Manitowoc. So if my investigator was saying, hey, they're monitoring you, even if it was that slight, that little bit, it doesn't matter. That is something I would pay attention to.
I'm trying to find this. I literally just looked at it. It's crazy. I've got so much stuff. Hey, I wanted to say while we're got a little lull here where y'all stopped talking, I wanted to say I saw Jamie in the crowd. Hadn't seen him in a long time. Welcome, buddy. Kelly,
yeah,
everyone.
We got a new one too. We got a new watcher, Michelle Stafford. Welcome.
Well, yeah, absolutely. Yeah, absolutely. Yeah, I don't see it there. I can't really find it quickly.
Doc, the doc's in, so morning, Doc. Hope you're feeling good.
Oh, Doctor, yeah. Well, he had messaged me. He's awake. I think he's IVing coffee right now.
Yeah.
So
intravenously.
Yep. Anyway, let's get back.
I do want to say, Nan's Life said, not true. When LE search with a warrant, you are asked to leave.
You step out of the house. But I've never been
in that situation, so I really would not know. And of course, I know nothing about the law, what the real, right to the bottom of the line would be.
Oh, if you're the subject of a search warrant, even if it's just your house or your property, you are allowed to be there. They can't send you away.
They just make you sit down.
I'm pretty sure they've got an eagle eye on you.
They just make you sit down and just let them do their thing, right?
Just do their thing.
You have to stay out of their way. You can't hinder them in any way, but they can't make you leave.
That's right.
Short of arresting you.
Right.
Well, yeah, they're going to probably arrest you once they find what the search warrant specifically says to get. In other words,
But yeah, the whole idea of being able to take charge of a property for a week, yeah, that would be unheard of.
Okay, I may
That's
have
what I
found
thought too.
I may have found it here. Let me see. Let me pull this up.
Jack says forever. Hard looking for you there, Crockett.
Did that pop on the screen there? That should be on screen now. Yeah.
Probably a second. There's a delay.
Yeah, there's a delay. It's going to pop on the screen there. I did find the memo. I had it. Never mind where I had it. I had it though.
Yeah. There we go.
Yeah, it's up there now. This is Exhibit 1 to Buting and Strang from Pete. There it is, the date, July 20th. Pursuant to the request from Mr. Avery, I traveled to Calumet County Jail this date, arriving at approximately 11 a.m. Mr. Strang had contacted the jail and advised him that I was coming. Jail staff met me and requested identification, which I supplied via Wisconsin driver's license. The jail officer took the driver's license and returned a short time later and advised that the jail administrator wanted to know if I was a licensed private detective. I advised that I was not, but I was meeting with Mr. Avery at the direction of and as an employee of Mr. Strang, attorney for Mr. Avery. The jail officer then advised that I would be required to interview Mr. Avery in the visitor's room via phone and then show me to the visitor's room. The phones are clearly marked as all conversations are recorded. At that time, the jail officer asked how long the interview would take, and I advised it would take less than 5 minutes, since I could not discuss anything over recorded line in those security conditions. The jail officer, a very large man in uniform, left, but returned a short time later and took me to the interview room, which was in the same room where I had previously interviewed Mr. Avery, while in company of Mr. Strang and Mr. Buting. As the jail officer was exiting, he turned and stated, you know that everything here is recorded, so anything said is at your own peril. Mr. Avery, yeah, really must be a thing that goes to school there. Mr. Avery was brought to the room and I advised him that what the jail officer had said regarding recording. I advised Mr. Avery that under the conditions, he should not say anything to me about the case. He acknowledged and said that he just wanted to tell me to check out Scott, his sister's boyfriend. I stated I would relay that to Mr. Strang and Mr. Buting and suggested that we continue our conversation to how he was doing at the jail, how the food was, etc. The remainder of the conversation merely involved those subjects. During the conversation, I examined the room and could not locate any overt equipment, signs, or any indication or warning that the events in the room were being recorded. Since the jail officer appeared to be candid and honest in his advice that a recording was being made, I can only conclude that any such action was done covertly and absent a direct modification such that to me will occur without knowledge or the consent of the room's occupants. Conrad Batts. Now there you go. Ain't that some shit?
That's some shit not to overlook.
Yeah. That's July 20th. July 20th, 2006. I'll let y'all talk.
Well, yeah, when you're an attorney, especially in the local area, you're going to know what the policies are in the jail. You're going to know where you can and cannot talk to your client. You're going to be aware of things like that. So if this was a situation where Buting would have known that particular interview room would not have normally had a recording device, I can see why he'd be surprised that there was.
Yeah, I agree. Hey, Dr. Silkman.
Hey, how's it going, guys?
Good. How about yourself? You get that coffee, Ivy?
Oh yeah, I definitely need it. That's for sure.
Good.
Yeah, no, I'm listening in. Fantastic so far. Really enjoying it.
Anything
Sorry, Jack.
Go ahead.
How do you like the word peril? I mean, come on now. I've never heard that word before, and now I hear it from Fallon, and we hear it from a jailer.
You do so at your own peril. What about that?
Yeah, there seems to be a lot of common language among the state actors.
Yeah.
Yeah, that
just sounds like a threat to me.
Yeah. Yeah, but not only that, I mean, even in that, the investigator himself said that there was no cameras or anything like that, or any notices or anything like that he could see, So, and
Then
as
hope.
Sapper said, Butin would know the policy and know that that's against their own policy. And again, we know that they're quite fucking handy at going against their own policies. But even the investigator says he couldn't see anything, and when Jerry's or that's went into the room, they've probably had to look themselves and no thought because they can't see anything that it's no happening.
Barring me looking it up, and I'm not going to because I pulled the rabbit out I had on this one and remembered where this document was, but somewhere around this time frame, and I'm going to say it was right before this memo, that Buting and Strang, where they were in pretrial and they were questioning the different reporters that came in. They also had, like I said earlier, John Byron, the jail administrator, under cross-examination. So this all struck me as like, what the, what? I'm not going to say the word, but but it's all in this time frame. So, and I'm sure they were well aware that they couldn't, or that the jail policy that they would not be recorded. They could go in there and talk about whatever without fear of being recorded. So, questions? Anything that we need to talk about before I move on to this little next part here?
No, everybody's pretty much agreeing that hearsay.
Except for hearsay.
Okay.
So Part D here, he's requesting a hearing. He cites a case here. He's talking about defendants and their attorneys holding in a bugged room. I'm not going to read into all that because it gets off into some other different things that gets a little deeper than what I want to go with this. This next part, Section 2, Avery was denied his rights under the Fifth Amendment Constitution when the state commented on his silence during closing arguments. And I had really forgot about this. As everybody knows, at least here in the United States, the defendant can choose not to testify, and a prosecutor or the judge can make any reference to that because they chose not to testify. They can't hold it against them. They're not supposed to anyway. I'm sure that some do, but they would like to see somebody get on the stand. But there are reasons why a defendant might not want to get on the stand, and they can be as wildly different as night and day. For Avery, obviously, he's got a past, even prior to the Penny Bernson thing, and that goes directly with the Sandra Morse thing, which is really idiotic and stupid of him to do. He paid the price for it. He was found guilty, and he served his time. It doesn't matter; they can still bring it up. And then going back before that, he has some other scrapes here and there. They're going to bring out that cat. That poor cat's been burned to death. I don't know how many times now. So they would have beat him to death with that, I'm sure. So, and they, Kratz tried. Go ahead.
Go ahead. I'm sorry. I was just going to say, and he's not, of high intelligence in a courtroom. And I'm not saying he's stupid by any means, but he's not, they could trick him up.
That's right.
They could, trick him up pretty easily. So your defense looks at that. How are you going to be on the stand? Are you going to be able to stand the pressure of questions? And are you going to be able to answer them intelligently? Them are all things that they look for. So I'm sure they looked at that.
Yeah, exactly. No defense lawyer worth their salt is ever going to allow their client to take the stand because it has too much potential to open doors that you may not want open. So it would be exceptionally rare to allow your client to take the stand.
Yeah, there's. I think a lot of times there's really far less benefit that can be gained than harm that can be done. I guess that's my way of looking at it. So, I'd actually forgot. Oh, there's Kratz now. I mean, Susan.
Hi, sweetie. Don't forget that Brendan took the stand.
He did.
No, it does happen.
It does, and I'm not sure. I don't know if that was a good thing or a bad thing because I don't know. I guess that I wanted him to say, I just told them what they wanted to hear, and that just in exactly that manner. I told them what they wanted to hear because no matter what I said, they called me a liar. That's what I wanted to hear him say, and it never quite came out exactly like that.
Yeah, there was a lot of I don't knows.
So for Brendan, for Brendan, I get that because he doesn't think,
Right.
necessarily like we do. So I get that. But anyway, did you remember that part, Susan, where Kratz had talked about? I actually went back and read this afternoon several of the arguments surrounding in the closing arguments, and they actually had to break because Buting, or I think it was Strang actually, that had a problem with what Kratz was doing. Do you remember that at all, or no? Not really.
In regard to what, Jack?
Him talking, Kratz bringing up basically, or at least alluding to the fact that Avery didn't testify and answer certain questions that he had the answers to.
No, that's not coming to mind. I'm not sure.
It's on down here. I'm going to read it. I'm going to read that part. It's not very long. I actually pulled up the trial transcript, but it's actually in here, and I don't really have to, and there's not that much to it. But anyway, the legal standard, direct comment on the defendant's failure to testify is forbidden by the Fifth Amendment. Okay, yeah, that's true. So he goes on in his argument on the 23rd day of trial. Attorney Kratz made reference to in his closing argument to fact presented, contested, and he's got the trial transcript in the day. Attorney Strang objected to this and asked to be heard on the issue later. The judge then reminded the jury on closing arguments are merely argument and not facts. Specifically, Attorney Kratz said, the facts in this case, as presented, and I will present to you, are very much so uncontested, uncontroversial. At least most of the facts in this case are uncontroverted. And then there's another section here. Attorney Strang's commentary outside the presence of the jury was, I initially interrupted Mr. Kratz's argument reluctantly and trying to be polite and somewhat circumspect about my comment that it was unwise and improper to describe facts as uncontested. I waited till we got to the PowerPoint slide that said fact number 4, and by my recollection, that was the 4th time that the counsel for the state returned to the theme of uncontested fact. As I say, I was trying to be circumspect, but the concern, of course, was that this comes too close to commenting on the decision of the defendant not to take the stand, or for that matter, not to offer witnesses that he did not. Mr. Kratz, in responding to my objection, I think made the problem substantially worse. I don't have committed to memory. We could go back to the court reporter's notes if we need to, but the rejoinder from the counsel from the state was that, if you remember a witness being called, or if you remember someone saying this didn't happen, something to that effect, well, then that's fine. But of course, suggest was not called and no one did speak up to contest that fact. Doesn't warrant a mistrial, but comes way too close to commenting on the Fifth Amendment privilege not to testify, and I think warrants some curative steps, either by counsel himself or by the court or both. So anyway, it goes on to this section, and I went back and looked, and it is there. So he didn't really take it out of context. So this is another section, or another piece of his 974-06 motion. There are other things in here. I'm not going to go into all of them. Avery's denied the due process rights under the United States. He goes into unbiased judge. He cites a lot of cases there. I'm not going to get into that. He rattles off some things that were said. By the way, this document is linked in the description, so anybody that wants to go and look at it can pull it up themselves. It's linked to my drive, so there's nothing hidden. And I highlighted some things that I just wanted to read out, not necessarily talk about too much, but it's there. Avery was denied his right under the United States and Wisconsin constitutions to effective assistance of counsel for failure to suppress evidence. This gets into the search warrants, and Doc, I know you talked quite a bit about that at some point. The warrants were void for lack of a court seal. He also gets into talking about, I probably skipped out here.
Jack 61.
Yep.
Yeah, that actually is a very interesting point. He does mention about the search warrants, and some of them didn't have the appropriate court seals. I think some of them didn't have the appropriate signatures. Ken Kratz actually signed off on a lot of the search warrants. But if you actually read in the document, or I think the response to this pro se motion, they said, Wisconsin law says you don't need the seal. And I'm thinking to myself, these guys are just making it up on the fly. But the important thing is that in Wisconsin, right? Because if you have a look at the reply, it's a 3-page summary of a reply. It actually says that you don't need the seal, the court seal in Wisconsin. So that's I'm not sure whether that's a particular law only pertinent in Wisconsin, but yeah. So all the arguments that Stephen had regarding those search warrants, according to the response, was null and void. There was no issues there.
Well, you
forget a seal. I mean, I can understand something like a seal, but it has to be signed by a judge. The DA can't sign a search warrant.
But Kratz did, and which is this part right here. Kratz you guys talk about it.
Yeah, Kratz did.
Yeah, that's I don't know how they can call that valid. Yeah, as far as I know, it takes a judge to sign a search warrant.
Yeah, well, I mean, think about it. With the search warrant, they were there for 8 days. I think about 8 days.
That's right,
8 days.
And you know what their excuse was? It was brilliant. Oh, well, hey, it's a 40-acre lot. We have to check everything. That's why they were there in part 5. So that's why they opened up all the cars. They bought time. It's buying time.
Well, yeah, there was even in, I think, one dispatch call they were talking about on the, I can't remember what day it is. I think it was the 10th. One of the officers made the comment, well, this warrant is good for another 5 days. Yeah, it was 5 days. I'm sure it's what he said. This warrant's good for another 5 days, but, they were talking about coverage. Somebody had to be there to guard blah, 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 whatever part, and being able to work the overtime. So I'm thinking to myself, I thought warrants were generally, Sappercop, you know this better than probably the rest of us, aren't they generally 48 or 72 hours and that's it?
Typically, I've seen 48 as almost the most.
Yeah, that just really surprised me.
Specific. They're very specific on what you have to write what you want on that warrant and go in and get only that. You can't just go, I just want to get whatever and just let it all come in.
I mean,
you can't do that.
I mean, think about it. A 5-day warrant. I mean, that's just moving in. They just bring a suitcase.
8 days. 8
but I mean,
days. And
well, sure, but I mean,
that's what bothers me is they have to list specifically what they are looking for.
Yeah.
Yeah, Cherie says a search warrant definitely can only be signed by a judge legally.
Yeah, you got a problem there because there are a number of those search warrants. I've looked at them. A number of them were signed by Kratz. There's no judge's signature on them. How did that work?
Well, then if that's the case, then they're illegal. So they should have got fucking tossed out.
Doc, you have to help me out, but I remember that this huge argument that String and Buting put up to Willis about the search warrants and the legality. You remember that in the pretrial?
Yes, correct. And I've got the Court of Appeals response, and it says here. You don't mind if I just read it out a little bit?
Please do.
It says, finally, the magistrate judge stated, Wisconsin law does not require warrants to be issued with a seal of the court. So therefore, Stephen's argument about the fact regarding the legality of those search warrants, the ones that didn't have a seal of the court, is null and void. But yeah, there was a lot of the problem with a lot of those search warrants is that they were non-specific. They were very wide, right? So basically, I think they said we're going to look for Teresa, her body, her vehicle, and any weapons that potentially can cause death. So in effect, they
everything.
confiscated everything, and because it's a 40-acre lot, that they had to search all the buildings and every vehicle on that lot. So that's how they justified being parked there for about 8 days.
You know, another thing too that I just really even thought about, in addition to this, where else are they? They're in the Manitowoc County gravel pit. They're on Cuss Road.
Yeah,
so,
correct. Correct. But,
I mean, they knew for the start that it was a 40-acre plot. It's bloody huge. So why not put that in the warrant that you and your warrant when you're applying for it to be signed by the judge that you want it to be able to search all the buildings on the property and the property. And there's your warrant covered. There's all your bases covered, because then you can go in and you can search all the buildings on the property, and then you can go down and you can search the salvage yards. Why not do that instead of putting it in piecemeal by piecemeal, or not putting it in at all?
Well, I think that allows them to kind of make it up as they went along, but that's my opinion.
I think that's a really good point that Alice made. I think the search warrants were the way they constructed them were very dynamic and evolving. You know, how many times did we say, don't serve that warrant, because they were modifying it, right?
Exactly.
They're modifying it on the go.
Yep, I agree. I think that, well, I mean, of course, we were disappointed, Willis just, he didn't allow he allowed the search warrants to stand. So, everything that they brought in, during that time that Beauty and String were arguing against, it got thrown out. So, but anyway, Section B, the warrants were void because there was no record. I'm not exactly sure what all he was talking about in here, but it didn't really line up with what I know. I'm not going to read it all, but he put it in there anyway. Next section, Section 6 here, Avery was denied his right under the United States and the Wisconsin Constitution to effect assistance of counsel for failure to argue a break in the integrity of the state's chain of custody of his and Halbach's vehicle. And this is an interesting point that he made, is that when evidence is procured, it's supposed to be basically cordoned off and sealed. And we know for a fact that his car wasn't, and the Halbach RAV4 was not either. Now, it was put into a container, but it was not effectively sealed with evidence tape. So I'll just read this. This is not very long. Argument. The seals on the doors to Avery's vehicle were broken prior to being taken to the crime lab. Conversely, there were no seals placed on the doors of the Halbach RAV4. Avery argues that the seals on the doors are either non-existent or broken. This shows that there was a break in the chain of custody to that jury it should have been made aware of. I misspoke that. Avery's was sealed. The doors were. Halbach's was not. And that's interesting that they weren't. And I don't know, big old procedural mistake, in my opinion, a rookie mistake. Ertl and Fassbender, all of them knew better than that.
They should have processed the RAV there on the property. That would have helped a lot.
Well, forget helping. It should have been done in the first place, because what did you have at that point? You had a missing persons case.
That's right. Agreed. 100% agreed.
Well, they stopped it, and it was instantly not looking for her anymore.
Oh, they never were.
Yeah.
Not really. The searchers, the volunteers, I'm sure were, but I can't. The police clearly didn't do that. They stated they didn't. So,
Yeah, we've said it many times. All the officers on scene went out of their way to ensure that nobody got into that vehicle.
Correct. That's right. It begs the question, though, if they weren't going to open it, why didn't they seal it? That's an interesting point, and I really never thought about it. I can't remember who brought it up, but somebody did some. That's been several years ago now, but I'm thinking, well, you know what? You're right. I've never seen a photo of her vehicle on the property or being hauled or whatever, hauled in, and then it's crime lab of the doors and so forth being sealed up. So
they also never put crime tape around the RAV at the site.
No.
Which is really weird.
It is weird.
Well, here's their escape clause for that. At that point in time, there was no crime.
True. Missing persons and potential crime scene, but yeah, I see what you're saying. That is their way, their ticket out.
But in a normal investigation, Zabra, wouldn't they process the car right there? And then to look, if you're looking for somebody who found her car, you want to see if there's any evidence of, something, somebody left a note, there's
her phone,
anything.
Anywhere outside of Wisconsin, law enforcement officers would have gone into the vehicle. They would have looked for anything, like you mentioned. They would have looked for a purse, a phone, a piece of paper, something. They would have looked for evidence in that vehicle of where that person was or what their status was immediately.
I thought so.
I know that they made they made comment that
that was a big red. Yeah, that was a big red flag to me when they basically broke from protocol completely and locked that vehicle up and wouldn't allow anybody in it.
Yeah, they were talking about bad weather coming in and they wanted to get it out of there, but they could have easily brought that vehicle over to any one of the, I'm sure they had several open garages there at the property and searched it without, endangering anything on the outside being compromised. That's just me, though.
That's I hate part of my language, but that's a bullshit excuse.
They found that vehicle early in the day, and it wasn't raining like all day. It didn't rain until later in the evening, I believe.
Yeah, I can't remember. They've been there for several hours, I think.
It did rain heavily because if we went through it in Ken Kratz's book. So essentially, that they covered the RAV4 in all these tarps, right? And then Fassbender had the bright idea of taking off all the tarps in the middle of a freaking downpour.
Yeah.
Now, think about it. You got all this heavy rain on the victim's vehicle, potentially washing away blood and fingerprints, right?
Yep.
So that begs the question, why did they put tarps over it in the first place? Now, think about it. If you put tarps over that vehicle, it means that anyone flying above, for example, the press, can't see what you're doing underneath the tarp. So you never know, right? I mean, as a crime scene, people mention it. It's a crime scene, and it absolutely is a crime scene. It wasn't processed properly. Now, think about it, right? They found the victim's vehicle. It wasn't raining. It was daylight. Why not erect a temporary, like a tarp, a sort of like a temporary tent?
That's right.
And process it there. Get the CSI team there, all wearing gloves and suits, and having a look to see inside the vehicle what's there. As you guys have said, is there a phone? Is there any signs of foul play? Anything. They sat there for hours and hours and hours. And what do? They moved the RAV in the middle of a downpour.
And it was nighttime. They had all day. They could have that crime lab out there. Boom, bam.
Correct.
I mean, weren't they already on the property anyway? I mean, let's get real. They should have processed it right. It was completely the wrong procedure.
100%. And it wasn't even sealed in crime scene tape, which means that anyone could have opened up that vehicle. Right.
Yeah, and did it not disappear for 2 hours or not?
Well, the thing is that the time taken for the transportation of the RAV4 took much longer than what, if you look at the GPS and a Google map, it took much longer to, yes, it was raining, but it took an extraordinary amount of time to get to the crime lab.
Yep.
Doesn't that seem like it's, with it being on the property under a tarp, all them
It's very
hours?
suspect.
No, yeah. I mean, like, that's time to put blood in there or do whatever they want to. I mean, that just seems very wrong all the way around.
I mean, the chain of custody, in effect, is broken because you've removed an item from the scene of the crime and you've taken it into your laboratory, right? So, their excuse is, we wanted optimal conditions, blah, blah, blah. But as Jack 61 said, hey, the Avery family's got plenty of big garages there. Move the vehicle there, make sure that nobody comes in, process the vehicle there, in situ, take your photographs, do your swabs. There are no questions. But by moving the RAV4 in the manner which they did, arouses suspicion, and they deserve all the criticism leveled at them for breaking the chain of command. And remember the person that went into the RAV4 the very first time? Oh yeah, the driver's side door was open.
Yeah, open.
Thank you very much. It was all locked. People actually tried to get into the RAV4 while I was at the property. So someone unlocked the driver's side door.
Yep.
Well, that comes down to that report that I can't think of his name now. I guess it was Harrington called Fassbender and said, hey, we had to get employ a locksmith. He didn't say he made a key. He said they had to employ a locksmith to get into the RAV. So.
And every cop has a Jimmy.
Well, that's right. They could have found a Slim Jim. Yeah,
and that's what they use it for.
They could have found a Slim Jim. They could easily gotten a warrant, to go into the vehicle because of exigent circumstances, I'm sure, without a problem. So, I don't know. I have a real problem with it. Them not opening the RAV immediately on the property and doing their deal right there.
They should have. And a missing person, you should be looking for clues to get that person. Makes no sense to just look at her vehicle and, don't nobody touch it. Let's cover it up and then take it off when it's going to rain and then bring it to a crime lab. Where's this person? You could have found a note in there. You could have had her phone and said, this guy's taking me. You know what I mean? They could have possibly had something leading directly to her.
Well, at minimum, they might have found her phone.
Unless they had foreknowledge that she was dead.
They knew already, yep.
Yep. And that way they weren't in a rush. Their aim, therefore, was to connect Stephen to the crime.
Well, that's what I'm going with. The whole gist of everything that took place on the salvage yard from the point they found the RAV throughout the point where they had control of it, it was on the fact that they already knew she was dead and they were processing their framing plan. That's what it was all about, because at no time was there ever any indication that any law enforcement officer was looking for Teresa. Why? Because they already knew she was gone. So they, the question comes down to how did they know that, and then shoot from there. And because the main thing with the missing persons case is what's your key element, whether it's an adult or a child? Time. You have no time. And the fact that they took that RAV, and from the moment they took possession of it till they opened it at the crime lab was 14 hours?
Roughly. So, I think that they got there. They roughly got there a little before 11 when the cops got there, and then I think they pulled off the Avery lot. I'm gonna say it was around 8:30 ish, 9 o'clock. Does that sound right, Doc?
It was evening, correct. And we can actually look up the weather maps to determine the actual time that it started to rain.
Yeah, but not only just that, though. You've got is Stephen Avery in custody? Do we have a body yet? Is Stephen Avery in custody yet?
Well, that's another aspect of it. We got Jacobs calling, Jinx's favorite little buddy there. Did we have a body yet? Is Stephen Avery in custody? What?
Exactly,
we just found this. What's going on here, man? What do you mean by that?
So their actions basically telegraphed the fact that they already knew she was dead. And I think the whole point of putting the tarps over the vehicle, like Dr. Silkman alluded to, was for certain somebodies to put what they needed in the RAV. And that's why they were okay to take it off when it started raining.
Yeah, I
If
think
I may
about that.
say something.
Please do. Hey, Lady Neverly.
Hello, Gentleman Jack. Yeah, they told Mike, and he told the world that they told them that there was no sign of foul play when they found the RAV.
Nothing nefarious here.
Right?
Yeah, right. There's nothing going on here, guys. Come on. It's all on the straight and narrow.
Just a little blood swabbing and, hair planting and whatever.
It is interesting, though, that Avery did add this to his pro se motion. I thought it was a really interesting and observant point that the RAV was not crime scene taped. Now, does that matter? I don't know if it does or not. I just know that without it being taped, it allowed someone to potentially enter it without anyone else knowing.
Okay, now here comes a question for you.
Yeah.
Now that he's put this in his pro se, now does that mean that KZ can't bring up the RAV? Is that going to be prosecutionally barred?
Well, she can't bring up anything having to do with what Avery mentioned. So, she can't point to any fact that it was not taped or anything like that. All that's going to be done. Just like with the jailhouse video piece. She can't use that either because that was in a previous motion.
Well,
Okay.
Well, I don't know about that one. I'm not sure about that one, Cypher, because now he did mention them being him being surveilled. However, he had no idea about the video.
There's no proof, right?
I'm sorry?
No proof.
Right. He didn't know that. He just was, he just heard this information that they're being recorded, and he had no way of, accessing or getting any kind of video. Even with the investigation that happened after this pro se motion that the judge ordered, he hits the investigator, allegedly hits the stone wall, finds nothing, runs up a, $3,000, $4,000, $5,000 tab that the county has to pay, but they're left with nothing. And then for 2020 was it 2019?
What did the
go ahead.
I was gonna say, what did the court rule on that specific point?
Well, when he reported back that he couldn't find any information about any surveillance, Judge sucks at this, denied the motion. Said, nope, you weren't surveilled.
I have something that repeats itself here by I don't recall.
Yep.
And earlier she stated that the article in section where it was a requirement for a judge to sign a search warrant. And I told her it's not a requirement. She said it absolutely is a requirement that a warrant be signed by a judge, not a DA. The opinion says it doesn't need a seal of the court, not that a judge's signature isn't required. See E2.
Yeah, that's a game. That sounds to me like a game of semantics. So they said it doesn't require a seal because that's all Avery pointed to. If Avery would have said it had to been signed by a judge, then they would have that. But he didn't. He only talked about a seal.
He did. He did talk about it too. About Christ signing it. It's back up here.
Oh, okay. And what did the court point to on that?
I don't know. I didn't look that up. Dr. Silkman might have that opinion handy.
I've got that document, the response. They don't even mention it. They don't even mention about the DA signing it. They only talked about the seal.
Okay, well, that could be an open door then. If
I think so.
There's no record.
And they also commented that a judge from a different jurisdiction had signed it, and Avery's argument was that he had no legal standing to sign the search warrant. It was another judge, and their argument was that they have, I think the word was, absolute judicial immunity So in other words, they could do whatever they want. Yep, that it was called Judge Gritton. He was from a different jurisdiction, and they found no issue with that.
I'm not even remembering that guy's name. That's
Yeah.
wow.
I don't recall. Says the court only addresses the fact that a judge from another county signed it. That was it.
Correct, Judge Gritton.
Oh, so a judge did sign the search warrant.
Well, this particular search warrant, because
Okay,
there were several search warrants, of
Oh, yeah.
course.
Yeah, I seem to remember there was three or four.
Yeah.
Oh no, there were many search warrants.
Yeah, they
Yeah,
just weaseled around the one that was signed by the DA.
Yeah, the one that Judge Gritton signed was to seize the bookcase.
Oh, that was in December, I think. Yeah, I think that was December 2005 when they went back.
I think so. That's when they seized the bookcase.
I'm trying to find this section here where he said that Kratz is the one who signed the search warrants because maybe I'm going crazy. No details about the judge, suppress evidence. Warrants were void for lack of court seal. We talked about that. Warrants were void because there was no record. Again, I talked about that a little bit, but I didn't really get into that one. Chain of evidence, and this is where we're at now, talking about the chain of custody, or the chain of custody for the RAV4 and it not being sealed properly. Okay, maybe I just told a big fat lie there, and he didn't mention it. Okay, well that's interesting. Okay, so I mean, I don't know how that could potentially play out now, but I think that Linda,
She said page 29 mentions Pratt.
Page 29.
I'd just like to say I'm following some of the comments in the chat. Crockett was saying that he thinks that she should take it to the Supreme Court level and if necessary, federal level. Crockett, she has always said that
there you go,
she
Gen X.
doesn't want to go the federal route when it comes to Stephen. I don't know why, and I don't understand why. I think it's because she can win better in a higher court or something like that, is it? I mean, somebody can correct me if I'm wrong, but she's always said that she will not go the federal level when it comes to Stephen's case.
I think that constitutionally, she stands a better chance of getting a reaction from Susan. I'm sorry.
You just passed it up where it says about Kratz.
Yeah, it's right there. B, warrants.
This one right here. The warrants were void because there was no record. The warrants defective because there was no indication that the affidavit had ever had been seen by the issuing judge. Okay, yeah, that's what The affidavit was witnessed by an active prosecutor in the case, Attorney Kratz. Wisconsin 968.23 gives an example of an affidavit for a warrant. At the bottom of the example, the legislature took the time to put that in the text. Judge of the court, I guess he means blank there. Clearly, the legislature saw that the United States Constitution requires that a neutral magistrate be accordingly placed between the state and the defendant without a way of knowing that the judges were actually involved in the process of establishing probable cause. The procedure was invalid and the warrants are illegal. That's a good point because it seemed to me like there was at least 2, if not 3 warrants that were signed by Kratz. I'm sure of it. So, okay.
I think that's a pretty big deal.
I'm sorry. I'm sorry, Sammy. What was that?
That's a pretty big deal.
I think so. I just I can't remember thinking back on it now in the pretrial if Beauty and Strang ever broached that subject. I don't think they did, but they might have. But I don't recall. So that's an argument for another day, though. Anyway, we talked about the RAV4 and the no seals on the door. This next action, I'm not going to talk too much about it. I just highlighted it because he included it in his pro se motion. Avery was denied effective assistance of counsel with the charge of felon in possession of a firearm wasn't served. So he does talk about in his argument. I'm going to read some of this right here because it is interesting what they did. Because this is an after the fact kind of thing. Argument. When Avery was first arrested, it was for the charge of a felon in possession of a firearm. Eventually, that charge expired due to the procedural requirements since the state failed to bring Avery to have a probable cause hearing inside the statutory time limit. Avery was subsequently charged with first-degree intentional homicide and mutilation of a corpse. Eventually, the state recharged and dismissed the felon in possession of a firearm charge, and it was joindered, that's a new word, without objection. At trial, Avery stipulated to the element of being a felon. In so doing, Avery introduced evidence against himself that would normally not be introduced to a jury unless he took the stand. The jury was then aware of the fact that by Avery's own admission that he had been previously convicted of an infamous crime. The joindering of this charge was unfair and should have been challenged. Interesting. But there was a deal, if everyone remembers, I think we just talked about this not too long ago, that Avery was able to get a hunting license. Everybody remember that? And he really, because of his charges, this is after he got out of jail in 2003, he really shouldn't have been able to got that to get that license. But they let him have it. And I think it was Deb Strauss that did a lot of the legwork on this, trying to run down how, where this happened and so on and so forth. And they had to do a little bit of legal maneuvering there. Anyway, number 7, Avery was denied effective assistance of post-conviction counsel when they failed to argue that he was entitled to a new trial due to a retroactive misjoinder. I'm not going to get into that one. I don't think. Yeah, that's about the mutilation of a corpse, but that's an argument for another day. Number 9, Avery was denied effective assistance of counsel when his attorneys have failed to develop an argument based on available information that the state had planted evidence. Number 10, Avery was denied due process because the court was incompetent to hear an appointed special prosecutor. That's interesting. 11, Avery was denied his due process rights, Sixth Amendment right to have an unbiased jury. He did talk about, and this is an interesting thing that he added in here about these various jurors. I'll read a little bit of this first line here. I didn't highlight it. Avery had a multi-million-dollar lawsuit pending against Manitowoc County at the time that he was charged and brought to trial. The people of the county who made up the jury that judged him were liable to him if he won. Arguably, he was in an excellent position to do just that. His suit focused on the wrongful acts of law enforcement that were discovered due to the efforts of the Innocence Project and revealed his DNA did not match what was found on the victim. He talks about these various jurors, which I thought was interesting. Everybody can pull up this document if they want and read about that and their connection to the Manitowoc County Sheriff's Department. And he's talking about these people should have been struck for cause for whatever various reasons. It's an interesting read. I've read that before. Here's another one. Juror Timmy should have been struck for cause. Actually, that's 3, 4. So there's 4 right there. This is the end of his pro se motion. There's 4 jurors right there that he named off that should have been struck for cause, and he has some information there about them. So the reason I did this, and we can talk about it if there's any questions, the reason I did this is so people could kind of grasp, and they can go grab the document if they want and understand that this motion, when the owner took the case, and she brought about her 974-106 motion, this one had to go away. It had to end. So that's what she did. Right, wrong, or indifferent. Now, I think that personally, there are many good points in there that really, for me, is one of the reasons that I really got interested in the case, and that's due process. For me, due process was completely trampled in this case for both Brendan and Stephen, just like trampled. Not even considered in many areas of the legal. I'm not a lawyer, but I'm old enough to have been. I've been around it enough to see that that's what we see written as the written word of our law. Just didn't happen, even for Wisconsin. It just so many weird and odd things, so they could end that lawsuit and jail and re-jail Avery.
Right. So now tell us, Jax, what you read today that gives you hope.
I'm not done yet.
Oh, damn it.
Maybe that is the next part. Yeah, okay. This is the next part. It's going to pop in there in a minute. Give it a second to the delay, but this next part is the Court of Appeals' latest their decision and a lot of the things that they wrote. Again, there's a lot here. I'm not going to reread what Susan and I read the other day. People have, I'm sure, have heard it or read it themselves. So, but I marked this specifically because I wanted to talk about the bones. As you guys know, I have a real problem and issue with how they talked about the bones issue. I have issue with the CD, the Bailey CD specifically, and how that was handled. I'm not going to really talk about that one, but this one I think is worth talking about, and there could be something here. I don't know. Maybe I'm reading it wrong. So motion filed, March 2019 supplemental motion, number 70, and you can see here that it's highlighted that bones there. I didn't do that. I was doing a word search. Number 71, Avery alleges that in 2011, state improperly released to the Hallbox family bone fragments from the gravel pit, which Avery wished to test to determine if they contain Hallbox DNA and might thereby indicate that Hallbox was not killed on Avery's property. Avery argued that the state, by its actions in returning the bones, was implicitly admitted that the bones were not only human, but they belonged to Ms. Hallbox. Avery frames this as a violation of Arizona v. Youngblood, under which defendants' due process rights are violated where the state either fails to preserve apparently exculpatory evidence or acts in bad faith by failing to present potentially exculpatory evidence. So, number 72. I think this is the point that I was talking about earlier before we started the podcast today. Avery represents that he was not aware and could not reasonably have been aware of the release of the bones until after he filed his fourth motion. We will assume, therefore, that this claim is not procedurally barred under Escalano-Naranjo. Is not procedurally barred.
It is not.
What is it? That's what I was talking about, because we read. I didn't. So see, that to me that opens the door crack. Maybe I'm wrong. Maybe we need Travis.
No, I would think it does.
Maybe we need Travis and Tracy and these our other lawyers to weigh in on this aspect of it, because I was rereading it. I'm like, wait, what? so anyway,
that would be the filing of them notifying Stephen that they gave the bones back. Correct? That's what right. That's exactly okay. So yeah. So what's that? Escarano Narvado or whatever it is. What does that mean?
Well, that's another case. They cited a case here.
Oh, okay. It's case law. Okay.
Yeah, that's case law. That's correct.
All right. Okay.
And I guess this procedurally barred is something that was decided under that case.
So it's not procedurally barred.
Yeah, but But did you read the explanation how they got around this?
I did.
So in other words, in essence, if it was potentially exculpatory evidence, they needed to first of all, they needed to preserve the biological evidence.
Yep.
That's one. Secondly, if they're going to get rid of any biological potentially exculpatory biological evidence, they have to inform Stephen Avery or his attorneys.
That's right.
And And I don't believe they did, because Kathleen Zorner was not aware that the bones, the cremains, were given back to the Hallbuck family. Remember, they gave her the CASO report and it was missing those pages?
It was
Right.
missing the last page, yep.
Last two
Correct.
pages.
Yeah, so
saying that, right?
Yeah, so her argument was, hey, I didn't know this. And a member of the research community had alerted her to the fact that the cremains were given back to the Hallbuck family. But those devious mofos came up with a brilliant explanation as to why a returning of the cremains were not exculpatory. And that's what I think you're alluding to, Jack. You're wondering, wait a minute, aren't they meant to be preserved? Well, according to their arguments, there was nothing exculpatory about them.
Right, because they went directly to the trial testimony.
Well, yeah, because Kratz wouldn't spend 20 seconds on it, correct?
Well,
that's what they hung their hat on, was they said because Eisenberg did not declare them human at trial, then they could have given back anything, chicken bones, bird bones, dog bones, whatever. So right. it was a non-issue. And the Court of Appeals, they because of that, they didn't care what they gave back.
Yep. And their argument was that the individuals who took the bones out of the bags, the evidence bags, were not forensic anthropologists, which meant that they were not experts. They had no idea what bones they gave back, and hence there's nothing exculpatory about it, right? And because Eisenberg did not state that the cremains that she examined at the Manitowoc County gravel pit were human, all bets are off.
Didn't they take the bones that were only human and give them back? They went by evidence tags?
Yes, I'm telling you right now, all the human cremains were given back to the Hallbuck family. There's no way that they would have received animal bones. They were all human bones. This is a trick. It's a ruse to overcome this very inconvenient fact.
Hugely.
Right? And that's how they got around it, by saying there was nothing exculpatory about these bones, giving them back to the family.
And see, that's the thing. To me, they're very misleading in their presentation of this, because they're saying that she didn't testify to it, but then they're going on to say, or they don't say, that, Fallon, Gahn, Wiegert, and Jeremy Hawkins, they go down to the bone locker. Pardon my trying to be gruesome here, but they go down to the evidence lockers with her Eisenberg's report, 8675. Bam, 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 bam.
But what the argument is this: Eisenberg, when she examined the pelvic bone fragments from 8675,
that's right,
said they are potential suspect human, or suspect human. She never said that they are human. If she had said that they're human, oh my God, they are potentially exculpatory. And that was said during the trial. So remember, the Court of Appeals only looks at the trial as the truth.
That's
so
right.
anything tapered outside, they don't even consider.
Yeah, so they're basically saying is that they just gave back bones that don't know if they're Hallbuck, if they are Teresa's or not. They basically just gave back bones that they have no idea. So, and the family's satisfied with that, right? And they just got away with that. That's
correct.
That's
bullshit. Correct. And you know why? I'll tell you why. Because no bones were DNA tested. Only a piece of charred tissue, muscle tissue. So their argument is, hey, this is how ridiculous it is. Oh, we actually don't know whose cremains that they belong to, because no bones were DNA tested. So hence, how can they be exculpatory if none of the cremains were tested? So we're
going to give them back to the family. We're going to give them back to the family anyway.
And not only that, in the Court of Appeals, for the first time, I read that it was the Hallbuck family that wanted the cremains back. That's the first time I've ever seen it.
But there's no
That's-
documentation to that.
Well,
No, I haven't seen any documentation.
I think I've got that highlighted. Let's see. The record reflects only that the state released bone fragments of indeterminate origin after the Avery's direct appeal was fully litigated, when there appealed no direct or immediate need to preserve this evidence. We're going to talk about 968-205 here in a minute, and I pulled that up too because we're going to see what it says. But anyway, and contrary to Avery's argument, the very fact that the state released the bones does not mean that these are Halbach's, or that the state acted in bad faith to destroy this evidence. The Halbach family requested those bone fragments for purposes of its own, likely for closure, but that does not vest these fragments with the evidentiary significance.
That's correct.
That just sets my hair on fire, Doc.
Yeah, well, in essence, they made the bones disappear. That's what they've done.
Yeah.
They've removed the cremains from evidence. Like that, just like that.
Yep.
Just like all the other DNA that they had, just made it all gone.
Gone.
Yeah. Gone, so they can't retest, do anything. So,
Correct.
See, like I said, they planned this crap from the beginning.
But
so
the bones are
be able to do.
The bones are a game changer.
Yeah, that's correct. But guys, don't you see? If Stephen was set up, and I believe he was, this is all part of the ruse, right? So by using legal trickery, they were able to remove the bones. They were able to remove the cremains from evidence. They never gave any bones back to Kathleen Zellner for retesting.
Nope.
Right? So think about what they've done. You've got no ability to retest any of the cremains. You've got no ability to retest the key and no ability to test item FL. The three critical things against Stephen are gone.
They still violated the law in doing what they did.
Yeah, but their argument is the state didn't act in bad faith and didn't destroy biological evidence, because they're saying, well, we don't know whose cremains they are. They could be anything. Now,
right.
You and
they
I
removed
know.
that. They violated the law. No matter what they have to say about it, they still, of all people, knew the law and violated it anyway.
Because they said it was non-human, and they got away with it. They legally
Wouldn't it
are
make
getting
it
away with it.
exculpatory though if they never tested it and they could test it now for new evidence?
No, here's the factor. And this all goes right back to Eisenberg, and that's why I think Eisenberg was coached to be very careful how she identified this stuff at trial. She said they were possibly, but could not positively identify them as human. So when that group got together in 2011 and gave them away, all they had to say was, "We just gave away bones. We didn't know what they were." And when they said that, and the COA said they are correct, they gave away bones of indeterminate origin, they gave cover to the officers and Fallon and Gahn for doing what they did. Now, the kicker is going to be, who has the power to get around that? I don't even know if the Wisconsin Supreme Court would counter that argument, because the Court of Appeals affirmed it. So I hate to say, but I think the bones are dead. They're gone.
Well, one of the things is
that
they also talked about there being no case law surrounding it, right? They did say that. So, with that being said, there could be
Crockett, hang on a sec, Jack. Crockett saying, "Oh my goodness, Court of Appeals didn't look at just trial testimony or evidence. Am I wrong about Dr. Jensen and the Court of Appeals saying Stephen could have placed bones in the quarry?"
I don't remember Jensen testifying to that. He might have. Somebody had to look that up to confirm, but I don't remember him saying that. I do remember Jensen saying that he believed that those two bullets, because who was it that pressed him? Was it Strang or Buting? That Teresa was shot in the head twice. And of course, they had been parading around these two bullets this entire time.
I think it was Strang. And also, Dr. Jensen made an error, because he said that the bullet had blood on it, and it didn't.
That's right.
Yep.
It was a huge. I remember that.
That's what led him to believe that the bullet transited the skull, because
So
the
bones-
brain. No. This is item FL.
Yeah. But those bones, were they not used to convict Avery in his trial in the end? I know Krabs didn't want to talk about him. I remember that.
Yeah,
but were they not used?
There's no. There's no dispute that human bones were found in Stephen Avery's gravel pit and in Yonder Burn Barrel number 2. There's no dispute. Dr. Eisenberg stated that they were distinctively human. Furthermore, Dr. Bennett, who first examined the cremains, said, "Hey, I found an ilium bone that belongs to a human adult female."
That's right.
So there's no doubt that but that's not the issue.
No,
the issue is they didn't want to talk about human bones outside the Avery salvage yard.
That's right.
Because what you're doing is you're expanding the crime scene, and you're now making it so ridiculous. Like if Avery went all the way, if he went all the way to the salvage, if you went all the way to the gravel pit, the argument is, why didn't Steve simply bring all the cremains together and hide them there? Right?
That's right.
So it now becomes more ridiculous. So Ken Kratz had to come up with the idea, all right, we suppress anything in the Manitowoc County gravel pit. We don't talk about it. And that means that the Court of Appeals looks at the trial and says, what human bones are you talking about? The state's forensic anthropologist never mentioned human bones anywhere else outside the Avery salvage yard, and that's exactly how they got it.
That's right.
Now wait, here's the real mind bender. Jack, if you don't mind if I just read a little
please do.
lines?
Please do.
Right. This from CASO. This is what Kathleen Zellner would have fallen on the floor when she read this, right? This is on the CASO report, page 1114, and I quote, property tag 8675. The human bones were separated from the rest of the contents and photographed. There you go. There you go. And tell me, see, this is exactly how the estate got around the problem of human bones. They mentioned human bones outside of the trial, right? Which meant that you could see quite clearly here. Kathleen Zellner presented Dr. Eisenberg's report that looked at the bone piles in the Manitowoc County gravel pit. What does Eisenberg say in her report? Burnt, cut, human bones.
That's right.
Well,
here you go.
He says the COA appeal said in their findings Stephen could have moved bones to the quarry.
That's correct. Their argument is this, and Ken Kratz says it in his book time and time again. He goes, oh, well, yeah, human bones were found in Yonder Burn Barrel number 2. Well, Stephen could have picked up those large cremains and brought them to the burn barrel.
Yep.
Okay. So in other words, Stephen Avery couldn't prove it wasn't him. Now Ken Kratz is using the same argument. Who cares if those cremains in the Manitowoc County gravel pit were Teresa's? Stephen brought them there. And he never stated that it wasn't him. He couldn't prove that it wasn't him. So therefore, they've got this incredible airtight argument to say, no matter where you find cremains, Stephen could have put them there, no matter how ridiculous it is. But guys, think about this. Think about this. The state made the cremains disappear from evidence.
Gone. That's right. And, this is another aspect. The Court of Appeals brought in and said that the Hallbacks made the initiation. Really? So you're not a fact-finding court? Where's this evidence at? Where is this documentation at? And I think that we have a right.
She don't state that, does she? Casey
No.
doesn't state that.
No. No.
And it doesn't say that on any paperwork she's gotten.
And that's why in every tweet that I've sent to Keller and to Buting, you'll notice I use the term assuming facts not in evidence.
Thank you. That's a good point too, because
Did the state mention that in any of their motions of like replies to KZ's motions about the Hallbacks asking?
I've never read that anywhere that the Hallbacks asked for that. They may have in the beginning, but I'm sure they were told about what I'm fixing to read here, 968-205. It's very clear. I mean, there are certain exceptions, and this document is also linked. I think I probably got it on my drive, but I put a link in the description for anyone who wants to go pull it up and read it for themselves. I mean, now it's the entire chapter of 968, but 205 is in there. You'll have to scroll down to, looks like it's on page 11. So, but
even Crockett says nowhere in trial did Stephen move Bones to quarry.
It's never mentioned anywhere because they had no Kratz or law enforcement had no evidence that Avery had taken anything up, and even worse, Kratz basically said that Teresa never left the property. He said that.
Yep.
But her bones did, and then they don't matter.
Right, and then this idiocy that, oh well, we have a state assistant attorney general that's going to come along and direct traffic and say, well, we're going to go pick out some bones out of 8675. We don't really know what they are, but Hallbacks want some bones back, so we're just going to give them some. Unbelievable to me, just completely unbelievable. It just blows me away.
Yeah, I'm with you. I like you said, your hair's on fire. Yeah, I hear you.
I mean, it fires me the hell up. I can't stand it. It just anyway.
I'm baffled how they can get away with this. How just a little loopy hole here and whatever word they, it's the legal word. So I don't know. I don't even know what to think of it now.
Well, and once again, not a peep from the Hallbach family. No. It was just told to them in documents and in the COA opinion that there's a good chance they got a bunch of chicken bones that were being presented as their daughter, and they don't care.
Do you think,
or do they know differently?
I'm going to tell you, I would never threaten a cop, but I'm going to tell you, if I had any inkling that these people had handed my daughter back, that something happened to her, and handed me something back representing her as my child, and it's really some old gopher bones and whatever, and they don't know what the hell it is, I'd buy a tank and drive through their building. Buck, come on.
Do you think they even know? I mean, do you think they even know?
I don't know. I would hope that somebody's informing them of what's going on. I would think
or the opposite. Do they know differently?
Well, I mean, Tim Hallbach's a lawyer. Tim Hallbach's a lawyer. I'm sure they know. Right? He's going to keep up with it, if nobody else.
Yeah.
So,
well, what I'm getting at is I'm quite sure the Hallbachs know that what they got back was Teresa.
Oh, absolutely. Right. Absolutely. I completely agree with that. I just don't think there's any way possible. It's callous.
Well, I'd like to see them bags because there was a definite chicken bone in there.
Well, and that's given if these bones actually even went to somebody.
Williams, in that phone call that he was wink making to Fallon that went to Zellner. We need to check those bags. Really? I mean, that whole deal right there, that's just he wanted off that case. To me, that screams, I want off. So anyway, I'm going to read out 968.
And that wasn't even addressed in the opinion, was it?
Oh, no. This was ages ago now. I mean, it seemed like it was only yesterday, but this guy gets brought into the case and he makes this mistake phone call to Zellner that was supposed to go to Fallon. He's worried about what's in these evidence bags. We better check them. She's making inquiries. We better find out.
Can I just say, Jack 61?
Please.
In order to prosecute Stephen Avery and Brendan Dassey of having murdered Teresa Hallbach, you need a proof positive identification that the victim is Teresa Hallbach, right?
That's right.
Now, the only thing that they tested, yes, they did some mitochondrial DNA testing, and they couldn't rule out Teresa Hallbach as being the victim. They also did a DNA testing of the charred muscle tissue and got 7 out of 15 alleles. Ken Kratz, during the trial, said it was 100% Teresa Hallbach.
Right.
Because you can't convict Stephen if there's doubt of who the victim was, right? So again, one starts to question, well, you really do need to test the cremains to prove that the victim is Teresa Hallbach, right?
Absolutely.
I can't understand what the state was so concerned about. You definitely want, if you're the state, you definitely want proof positive that the cremains belong to Teresa Hallbach, because that strengthens your argument. It doesn't weaken your argument. To me, by removing the cremains from evidence, you're hiding something. There's something about those cremains that you don't want the defense to discover. Now, why is that?
Well, there could be numerous reasons, but one of the things that comes to mind, and we've talked about, if those bones aren't Teresa's, then they've got another murderer that they've not even looked at. That's number one.
Correct. That's a possibility.
I don't know. I'm not sure what your next thing is, Doc.
Well, I'm just sort of stating there was a definite plan with those cremains. Definite plan with those cremains.
No
that
doubt.
was to give them back. That was to give them back. They must have heard wind about these new DNA testing techniques, right? Remember, they even argued that, look, they're not approved by the FBI. They're not pertinent to crime scene investigation. What?
Right.
This is how ridiculous their argument got.
I think Gone was actually DNA lawyer expert person, so he would know.
He knew.
Correct. Now, in that report, in that CASO report, it was Jeremy Hawkins, Mark Wiegert, Tom Fallon, and Norm Gunn. They're the ones that went through. They're the ones that went through the evidence bags and took out the human bones. I'm telling you right now that all those cremains had to have been marked in some fashion, that they simply went to the evidence bag and picked them out. Because if you're not a forensic anthropologist and you don't know what a human bone looks like, then all you're doing is you're giving random bone fragments to the Hallbach family. Every human bone would have been identified. And what's incredible, they even said that in evidence tag 8765, they took out the human bones.
That's right.
Right? So therefore, Stephen's concern, or Kathleen Zellner's concerns, is 100% correct. But because the Court of Appeals only looks at what was said in the trial, they bypassed it. They bypassed that loophole.
Which I'm hoping that... go ahead, Doc.
Yeah. I'm saying, what the hell is Tom Fallon? Is Tom Fallon now a forensic anthropologist? What about Jeremy Hawkins? What about Mark Wiegert? Would you want them to do action on you?
No way.
Come on, guys. This has now gone to Twilight Zone. If they said Dr. Eisenberg or Dr. Bennett came in, checked the evidence tags, and isolated the human bones, yeah, fine. But notice there's no forensic anthropologist there, and they used Eisenberg's report.
That's exactly what they used.
This is the blind leading the blind, right? Because very cleverly they took Eisenberg as a person out of it, completely out of it, because then the argument is, wait a minute, what's Eisenberg taking out human bones out of 8675 when she said that they weren't human during the trial.
That's right.
So their argument, Judge Flowers' argument was, hey, those guys, they're not forensic anthropologists. They didn't know what they were doing. Hence, they're not exculpatory. Excuse me?
Yeah.
That's the crap that they used.
That's right. That's exactly right. And that's, to the point of, this, I'll get to a little bit more here in a minute, but, this, how the Court of Appeals came down on her, it really drives the point even more, even though they did, and they're saying, oh, this stuff is procedurally barred, or, it's not exculpatory because of, what we just talked about. Remember, guys, everything that Zellner's done, with the exception of this procedurally barred stuff, even beyond that, everything she's presented is right. It is real evidence, and it's still there. Whether it gets to be included or not, it's still out there, and no one can really deny it. Whether they, moving on to up the chain of the Supreme Court, the Wisconsin Supreme Court, or the Seventh Circuit Court, that evidence is still there, and who knows what will happen down the road. But I'm going to read 968.205, so it's not that long. It's a little bit wordy from a legal standpoint, but I think it's important to understand what the actual statute says. Custody means that actual custody of a person under sentence of imprisonment, custody of or a probationer, parolee, or person on extended supervision by the Department of Corrections, actual or constructive custody of a person pursuant to dispositional order under Chapter 938, supervision of a person, whether in institutional care or conditional release, pursuant to a commitment under Statute 971-17, and under supervision of a person under Chapter 980, whether in detention before trial or while in institutional care, or on supervised release pursuant to a commitment order. So basically, they're defining what a person is. B, discharge date means that the date on which a person is released or discharged from custody that resulted from a criminal action, a delinquency proceeding under Chapter 938, or a commitment proceeding under 971-17 or Chapter 980, or if the person is serving consecutive sentences of imprisonment, the date on which that person is released or discharged from custody under all sentences. 2, except as provided in sub 3, if physical evidence that is in the possession of law enforcement agency includes any biological material that was collected in connection with a criminal investigation that resulted in a criminal conviction, delinquency, adjudication, or commitment under 971-17 or 980.06, and the biological material is from a victim of the offense that was subject of the criminal investigation or may have reasonably been used to incriminate or exculpate any person for the offense, the law enforcement agency shall preserve the physical evidence until every person in custody as a result of the conviction, adjudication, or commitment has reached his or her discharge date. 2M, a law enforcement agency shall return evidence to sub 2 applies to an amount and manner sufficient to develop a DNA, I can't pronounce that word, Dion can pronounce it. It's a DNA profile as defined in 939.
Deoxyribonucleic acid.
Thank you. As defined in 939.74 2DA from a biological material contained in or included on the evidence. Subject to, number 3, subject to sub 5, law enforcement agency may destroy evidence that includes biological material before the expiration of the time period specified in sub 2 if all the following apply. A, the law enforcement agency sends a notice of its intent to destroy the evidence to all persons who remain in custody as a result of the criminal conviction, delinquency, adjudication, or commitment, and either to the attorney of record for each person in custody or the state public defender. B, no person who is notified under Part A, Paragraph A does either of the following during the 90 days of the date on which a person received notice. Hold on, let me scroll back up here. Number 1, files a motion for testing of evidence under 974.072. Number 2, submits a written request for retention of evidence to law enforcement agency. Letter C, no provision of federal or state law requires the law enforcement agency to retain the evidence. So basically, they're saying right there that unless they're going to send out notice, and there needs to be a reply from the attorney at record or the prisoner, hey, we're going to destroy this evidence, and they can say, hey, nope, we're going to get to that right now. Number 4, a notice provided under sub 3A shall clearly inform the recipient that the evidence will be destroyed unless within 90 days, I said 30, it's 90 days after the date on which the person received the notice, either in a motion for testing of the evidence filed under 974.072 or a written request for retention of evidence is submitted to the law enforcement agency. 5, if after providing notice under sub 3A of its intent to destroy evidence, a law enforcement agency receives a written request for retention of the evidence, the law enforcement agency shall retain the evidence until the discharge date of the person who made the request or on whose behalf the request was made under subject of the court or issued, so forth, unless the court orders destruction or transfer evidence under, there's some exceptions, but we don't have any of those in this. So there's nothing here that says, oh, well, we thought that the appeals were done, so therefore we just were able to do what was inexplicable. And this is what I'm getting from the Court of Appeals. They've completely ignored this part or this statute in whole. Not in part, but in whole. Comments?
Correct. Because, yeah, that's correct. Because in their minds, in terms of analyzing the court record, that what was being, I'll say, alleged or stated by Zellner in her opinion did not violate Youngblood because she was unable to establish bad faith, which we all know is absolutely stupid because you cannot establish bad faith without what? A hearing. Why? Because the only way you can establish that bad faith is by questioning those who perform the activity and determining their intent or their mindset.
That's right. That's exactly right. So I just found it rare.
It's almost like a circular argument. They said you didn't prove bad faith, but we're not going to give you the avenue in order to do so.
Yeah. I mean, it's insane what they did here and have been allowed to continue to, they've just been given a big old attaboy and pat on the back from the Court of Appeals, which again, I'm not totally shocked at. I'm disappointed. But, if we're fair and thinking about how everything else has went so far with these various judges in the case, then we can't be too shocked. But I'm not going to let it get me down, guys. I don't know about the rest of you, but pick yourself up by the bootstraps and move forward.
Well, I mean, if you ever wanted to see shenanigans at work, legal shenanigans, it's point number 75 from the Court of Appeals that you read out about the cremains.
Yes.
It is absolute classic, the way they bypassed what you just read out regarding the preservation of biological evidence. So their argument is, what biological evidence?
That's right.
And even if they were Hallbark's bones, right, or cremains, Stephen didn't prove that he didn't put them there. So they got around the argument that they broke their own statute by saying they're not exculpatory. So hence, the officers that took out the cremains and gave them back to the Hallbark family, they're not forensic anthropologists.
Right.
They don't know what bones that they gave back, but the Hallbarks requested bone fragments. Now wait for it. Likely for closure. Right? So why not go to the freaking local butcher shop and ask for a couple of bones and say, yeah, this is symbolic. This is closure. This has got to be, no joke, I'm telling you now, even in 100 years' time, point number 75 from the courts of appeal will be used to show the absolute madness that occurred in Wisconsin. And Stephen Avery sitting in prison, and no one knows whose cremains they belong to. If you don't have a body, how can you convict somebody of killing
right.
that person when you haven't forensically proved that body is Teresa Halbach, which goes to show what Sappercop said. They already bloody knew the ID of the victim.
They had to.
Knew
They had
the
to.
ID of the victim, and everything after that was just show, process. All it was process. To me, this proves it. Imagine if somebody came to your door and said, please accept these bones. We don't know who they belong to. We don't know if they contain animal bones. Are you happy with that to bury them in a grave?
Exactly.
Hello? That's exactly what point 75 is saying.
That's right.
They ain't non-exculpatory. They had no bad faith. Stephen Avery couldn't prove that he actually put them there, and the Halbach family wanted closure. So if you look what they did. If you argue that point, then the guilters will say, look at you guys, you're picking on the Halbach family, leave them alone, let them be. That's exactly the type of process that was used throughout the trial. The Halbach family feels sorry for the Halbach family. And now all of a sudden, the Halbach family are happy to accept cremains that haven't been definitively proved to come from their daughter.
That's right.
I'm completely speechless.
Like I said, my hair's on fire over it. It just absolutely, it just knocks me away. It really does. That, and this is where you hope that moving forward to a higher court, that they see this more the way that reasonable people see it. Because from what, I get that they're trying to protect these convictions and not undo the process and let things happen as they should and get to the actual truth. They're still parading this fantasy. To me, it's just all fantasy. It's absolutely nuts. We're a little after 2 hours. I've got one more thing. I'm just going to flip through where we're closing out here. And I'm going to show you what I think is a real crime scene. If I can get it to open. Come on, open. Did you open? It did. Okay, good. It'll pop in there in a second. I think everybody will appreciate how this appears to be a real crime scene. Do we have any questions? I see the chat slowed down a little bit. Any questions? Anybody's?
No, not necessarily a question, Jack. Brandon, Dassey. Sorry, Brandon, if I've got your name wrong. He says, love you guys, never missed a podcast. Thank you for the amount of time you all put in and to continue to give Stephen and Brendan a voice. Been a pleasure to continue to fight along with you all. Thank you very much, Brandon. That's awfully nice for you to say, and thank you for your support for the boys and for us and that as well.
Absolutely. Yeah, I mean, it's
Yeah. Chance your Galatech, he wants to know where his steak is.
Hey, I got a question. Where's my steak? Rascal. Yeah, well, that's my second oldest for you. Hey, you need to be over here cooking me one, but we talk about that another time. I thought I'd close out today and just go through a few of these photos here at Cuss Road. This is what a real crime scene looks like. I think I can get a big yes from Doc on these photos, because they absolutely, more than anything, pretty much on the salvage yard for the most part, would remind you of a real crime scene where it blew up and there's crime scene down this road here. It extends back from this last silver car back into the woods. I think you can see it there. And then I think there's another part even behind it that it's roped off. Then if you go forward, up past the maroon car up to the right, there's a little gravel road that runs down through there. There was crime scene tape that ran all the way down that way as well. But there's nothing there but a couple of old rotten peat moss bags and a rotten pallet. Seriously? And we have a next one coming up. There's an ambulance. The first one, this is pretty early on, gets called over the crime scene, or Crest Road. I said crime scene, my bad. And then you can see where it's roped off here. It's coming up. And I don't know who's standing back in there, but of course I'm sure that's where the tarp, they had this tarp laid out back there where they were doing whatever.
Oh, is this Cuss Road, Jax?
It
the
is
the only place they treated like a crime scene?
That's right.
Yeah.
If I remember right, they even brought in lights so they can continue to search through the night and not just like put like guards on there until the next day like they did the Avery yard.
That's right. I don't know if I've got any of those in this. Several photos I got in this folder here that I just grabbed, and I thought I'd add it in here at the end. And just thinking about everything that we've learned. Again, procedurally barred doesn't make her wrong. And that's a sticking point that you're going to find moving forward. And, if you have any discussions with those that believe in guilt, I know that I've already begun making that point very loudly, and I will continue to make it. If they want to act like that procedurally barred means that she's incorrect and she's been debunked. Well, no, it really doesn't at all. And no way.
It's called a cop-out.
Yeah. Got a slide from Doc, one of Doc Silkman's presentations coming up.
The thing is that there are many issues. If they made the cremains disappear right in front of you, and they literally did, you can damn bet you that everything from Cuss Road is suppressed, and they did that too. The genesis of the frame-up job took place with what was found at Cuss Road. Right? Now, absolutely nobody in their right mind sets up Cuss Road like a hardcore crime scene for a peat moss bag, right?
No way.
Could you imagine if you called up all these reinforcements and your supervisor found out it was a peat moss bag? You'll be fired. You'll be issuing traffic tickets in your county. The amount of individuals that were at Cuss Road indicates that it's a full-on hardcore crime scene.
Sure did.
No doubt about it. And as Mystic Jing said, they even brought lights so they can continue their investigation throughout the night. So
that's right.
They played these shenanigans with the cremains. You can damn bet you that you're never going to find out unless someone talks what happened at Cuss Road. Now, something at Cuss Road that they found pointed directly to Teresa Horbach. And I believe law enforcement went to the Horbach family and said, I'm sorry, your daughter has been killed. They knew, they already knew, right? Because look at the sequence of events. All the cremains, all the main pieces of forensic evidence are found on the 8th, right? The day after Cuss Road. And Lord knows what they found before the 7th, because you look, did Mike Bushman write a report? Nope. Did Mike Bushman get called in front of the court? Nope. So therefore, what is absent, which is what is critical. So if they don't look at Colburn was everywhere. Colburn wrote 4 lines because he didn't want to commit anything to the record.
That's right.
Right? So you've got this massive group of people who have gone to Cuss Road, and in the end they said, nothing to see here. And don't think it's ridiculous, because they did the same thing to the cremains. They said there's nothing to see here, and we're giving you a legal argument why the cremains were not exculpatory. So if they could do that with cremains that you can see and were photographed, Cuss Road is a hidden entity. You've got no idea. So therefore, you can't even start asking questions because there's nothing to see there.
That's right.
Right?
That's right.
So hence, in my opinion, they got away with the biggest cover-up we've ever seen. And Stephen Avery paid the price twice.
Yep. Brendan
Twice.
And Brendan got drugged along this last time with this collateral damage. Yep.
Correct. And because what they're doing is they're legally stopping Kathleen Zellner from opening up any door.
Yeah, and that's why I've been saying for a while that the one and only thing that is going to break this case is going to be somebody from that inner circle, and I'm talking about Uyghur, Dietering, Fassbender, Colburn, Link, one of them, or Kratz even, if you can get him to that point, for one of them to talk. That is the only way this is going to break, because they did even though they did the most poor job of doing the actual frame, because they have the courts backing them inexplicably, they've been able to protect themselves at every level. So it's going to take one of them breaking and spilling the beans to do anything about this.
100% agree. Yep. They made the investigation for an outside entity so airtight. You can't, like, for example, if they were open and honest, if the state said, look, our evidence is so tight, we know Stephen Avery did this, then what the state should have done is, okay, we're going to hand you all the forensic evidence over and you retest it. And it'll prove that Stephen Avery had committed this crime. But what did the state do instead? Remove the cremains. Prevent Kathleen Zellner from getting access to RAV4. Do not mention CX. Do not mention A23. Do not mention the fingerprints. Nothing. So the version of events that they show in court is only a mere smidgen of the total picture, right? So anything that hurts the state is not mentioned at all. And that's why Ken Kratz did the big song and dance about the cremains found at the Manitowoc County gravel pit. He says, I'm spending 20 seconds there, right?
Yep.
And Cuss Road is suppressed, right? So all the harmful things are not mentioned. So the Court of Appeals will go, well, hey, they went to trial. Nothing is mentioned here. Why are you bringing it up now? So if Kathleen Zellner had an evidentiary hearing, she can bring up 30, 40 points, no problems, and destroy the forensic evidence to pieces. They don't want her even to open her mouth.
Oh, no. They want her out of that state. They want it gone. They want her to drop the case. You can tell by this. They want it away from them. But, I mean, to me, I don't know her and what her plans are, but I can't see her dropping this case whatsoever.
No, she isn't going to drop it. I'm still waiting for an answer from somebody on the legal side, whether it's Buting, Keller, Tracy, Travis, anybody, to expound on what power does the Wisconsin Supreme Court have. Is there a challenge against those bones? And if not, because that's the, aside from somebody talking, that would be the strongest issue. If she is able to challenge the opinion regarding the bones and get that issue open back up, then we have a big frickin' door we can walk through.
Got a ball game.
Granted, we can't test the bones anymore, but just the fact that they did violate that statute, they did destroy the evidence, that's pretty strong. But if that door is closed, if there's no way for her to challenge that, we're really in dire straits.
Well, unless she, finds if she has something new that would be procedurally barred from the June 2017 PCR 97406 motion, and there could be, the Sowinski matter. We talked about that. She's got to have connecting evidence. She's got to have a phone record to prove that he called. She's got to have it. Otherwise, to me, he may be telling the truth, but
I don't know he's telling the truth without that phone call. That phone call lends it some credibility. Otherwise, hey, all bets are off, in my opinion.
Yeah.
So, okay.
Well, and there's still the matter of the video as well. But I mean, without even knowing that the video still exists, or without knowing what's on it, it's really hard to determine, how what the strength of that particular thing.
That is another one she could bring up. She only recently learned about that, so that is new evidence, and that could potentially open some other doors that she didn't put in the prior motion for a new 97406. And not even knowing if she will try to appeal this decision, which I don't know. Given the tone of how they addressed it, I kind of doubt she will, but who knows? Maybe she will. I don't know. But
yeah,
they millimeter tape.
Correct. Can I just make a comment?
Please.
Yeah, I'm looking at the comments by Fish and Snails, and he asked the question, or she asked the question, do you think DNA from a single hair should be enough to release a convicted rapist? Which is very, very interesting because the pubic hair that was tested to exonerate Stephen Avery came from a pubic hair combing of Penny Bernstein. So the question is, how did the pubic hair belonging to Gregory Allen happen to land in the pubic hair region of the victim? Isn't that interesting? Isn't that interesting? And then you've got fuckwits like Jean Couchet, who openly admitted, where did it come from? Where did it come from? Look, there was one person that could have cracked this case right open and exposed the corruption. And unfortunately, he's dead. And that was Jean Couchet, because you could actually tell that he was pissed off with Kucerik. What did he say about Kucerik? He'll shake your hand and stab you in the back.
Yep.
So, unfortunately, he disappeared. But yeah,
I'm not going to do it.
Yeah, it's extremely frustrating.
Yeah, and that's kind of what I've been almost praying for this entire time, because I've said a couple different times that there's the whole position of no honor among thieves. All it takes is for somebody to feel like they've been wronged by the rest of the group, something of that nature. That's what I've been hoping for all this time, that maybe Colburn finally would realize that he's going to be the scapegoat if it ever came to it, and would go ahead and proactively come forward. It don't look like that's going to happen. But that's what I've been praying for, is somebody to feel like Kush did about Kucerik and decide to break with the rest of the group and say, you know what, screw this. Here's what actually happened.
Yeah, and push back.
Yeah, it's going to be an insider that breaks. And what Fish and Snails doesn't understand is that you literally don't have to put blood in the RAV4. All the shenanigans can occur inside the laboratory.
That's right.
Right? And we know one individual who's extremely vulnerable and who assigned herself to this case. And that's Cherie Culhane. All the swabbing was done by her. You've got no idea about the veracity of any of her results, correct?
That's right.
She was also part of the 85 case, if I remember right.
That is correct.
And she had a reputation to protect.
That's correct. And her fake hair evidence landed Stephen Avery in prison, right? No one uses that hair evidence anymore.
It's
now,
garbage.
why would Culhane, who got Stephen exonerated, put up her hand and say, I'll take the case?
I guess she wants to undo her mistake.
100% correct. She had to correct a wrong.
Well,
because the exoneration directly led to the lawsuit.
That's right. That's exactly right. Well, and on top of that, you've got these state law enforcement people contacting.
Yeah. If Fish and Snails goes, so you don't trust testing by Cherie then, even the hair. Let me tell you this. Cherie Culhane did not exonerate Stephen Avery. Gregory Allen's pubic hair did. And let me tell you this, Fish and Snails, the court ordered Cherie Culhane that if you don't get a result, the material will go to an independent laboratory. So Fish and Snails, do your research before you talk garbage, okay? Cherie Culhane did not exonerate Stephen Avery. The pubic hair belonging to the actual rapist did. And not only that, Cherie Culhane did the test twice to ensure that it was correct. And not only that, hadn't she got a result, the pubic hair would have gone to an independent laboratory. So Cherie Culhane had to do it right, or someone else would have done it, an independent laboratory. So she would have been sweating bullets. Let's hope to God that that pubic hair belongs to Stephen Avery. Well, guess what? It belonged to the real rapist, which not only Kuceric, but also Vogel knew about.
Protected.
Right? So don't come in this chat with your bullshit, Fish and Snails, right? Because you're only telling half-truths and you don't know what you're talking about. How can Cherie Culhane swab both vehicles and handle the swabs and keep them at her bench? Excuse me? So please do your homework. Don't come here trolling, right? This is what really annoys me about guilters. They talk crap. The one person that handled all the forensic evidence was Cherie Culhane.
That's right. Everything was filtered. Everything was filtered by her.
She's the one that used all the DNA on the key and contaminated the bullet, right? With the PCR negative control, which never should have seen the light of day.
Nope.
Right? So now you know exactly what the Court of Appeals are trying to do. They don't want Kathleen Zellner to prise open the forensic evidence, right? They don't want her to look at the forensic, because the forensic evidence will fall to pieces. They gave her item FL, and look what she found on item FL. Teresa Horbach was made out of wood, right?
And some
don't
paint.
give me that crap.
That's right.
Well, I encourage Fish and Nails to go to Foul Play site and read as much documentation as he can, and maybe he will change his mind.
Let's not forget Culhane's little deviation from protocol that never happens in a lab.
No, it doesn't. 60,000 tests she had done, and she had never done a deviation in her entire career.
But not only that, the deviation wasn't signed by her supervisor.
That's right. That's right.
That's correct. That's correct. But now they committed item FL, right? And that's why they can now not explain why item FL contains wood shards and not bone fragments. And what did the Court of Appeal say? Well, we never said item FL went through her skull.
I
there
love
you
that.
go. So they've got an answer to everything. I mean, they've got an answer to everything.
Right. They parade these two bullets around the entire time of the trial. Oh, we didn't say she was shot. Those two bullets went through her head. We didn't say that. Well, what are the bullets doing in here? Why did you introduce them?
That's absolutely correct.
And he's not Irish. He's an Australian.
Who? Me?
No. Yeah, he called you an Irish.
Oh. No, I'm Australian.
He's Australian. Well, yeah. I mean, if there's nothing, Fish, if you can't find what you're looking for, or you're looking for something, you need to let us know. If it's not on the Foul Play site, we probably, I'm sure we've got more files than any site out there. But if you can't find something you're looking for, let us know. We'll try to help you. Our belief we want the full truth. We want everything on the table.
The thing is that 100%. The thing is about fish and snails, whoever they are, they're trolling. So what they do is they throw out bait in the hope that someone will snap at them.
Well,
with people like fish and snails, I don't deal with them. And the reason why I don't deal with them is that all they want you to do is to get angry and lose your focus.
yeah.
But it's very important to realize the shenanigans that occurred against Stephen Avery started in 1985.
Absolutely.
Right? There wasn't DNA back in 1985. Right? Stephen Avery had 16 material witnesses. All of them were rejected. All of them.
That's
and
right.
it goes to show that only by a miracle that Gregory Allen left the pubic hair on Penny Bernstein, that Stephen Avery got released. And people like Peterson, in a court of law, said he still doubted it.
Yeah.
Stephen Avery's got no chance. Chance.
He didn't just have the 16 witnesses. He had a frickin' receipt that showed he was somewhere else.
Correct. But the incredible thing is they did a timed reconstruction of look at this madness. He has 5 kids and a wife that he went to the shop with. They did a time reconstruction in which the driver drove 10 miles an hour faster, and they didn't take into account all the things that Stephen Avery did, and their conclusion was Stephen could have done it. That's the madness of it.
Right.
And those five children, 2 of them were like newborn babies, just a few days old.
That's right. Not a chance. There's just no way. There's so many other things surrounding the 85 case too that's just mind-blowing. It's absolutely mind-blowing. And you got to understand the 85 case, how it moves into the 90, Bogle leaves in 87 or 88. He gets the hell out. Moves into the 90s. We get this phone call that allegedly that Colby gets, that gets transferred over to the detectives. But, we got the right guy or whatever. And then everything else just happens. And then finally, 2003, he gets released. It's all, every bit of it's connected. Peg Lautenschlager comes along and says, oh, no wrongdoing at Manitowoc. Oh, everything's great. But she was in a corner. We know that. Now, should she have ruled that way, in my opinion? Absolutely not. Clean house and make it right. Clean house and make it right. Make a stand. That didn't happen. So what did Stephen do? He had to turn around and file a lawsuit to get any kind of satisfaction. Well, when he filed that lawsuit, what happened? It's right there. All of a sudden, Peterson doesn't want to, or Kasorki, he's trying to backpedal out of testifying. So is Bogle. We shouldn't have to, that we're, stuff should be protected. I'm the sheriff, and this is, no, it's not. You got to get up there and testify. Well, what happens? All of a sudden, Stephen's arrested for murder. Sorry.
Yeah, he's about to become a multi-millionaire, and he decides he wants to kill somebody. Yeah. And not only does he decide he wants to kill somebody, instead of calling this person directly on their cell phone, no. He's going to call to their employer and ask for them because, he's a brilliant criminal and all.
Right.
Not just once. He called twice to Auto Trader, once at 8:12 in the morning and at 11:04 in the morning that same day. Yep.
And he's so smart that, and so, whatever, that he leaves to go to Crivets, but he leaves all this alleged evidence in his yard and on the property.
Yeah.
Come on.
Yet he cleaned up his trailer so good, just left the dust and all DNA was gone. So let's not forget that.
Well,
he's an idiot and he's smartest man on.
Savant. Yeah, that's quite amazing. He was able to clean all of Teresa's DNA, but he left his and Jody's. And the dust.
Clean the garage, but put back down the bullet.
The bullet with no dust on it.
Well, what about the bullet?
And everything in the garage was dusty.
Yeah. All right,
can't
folks.
have it both ways.
We're at 2.5 hours.
Jax.
It's been an interesting podcast, and the reason I wanted to do this what I did today, showing the 97406 pro se motion
that Avery filed to show what he included in his. Now, again, it's not very well written, and it's certainly he didn't have the ability to get what he really needed to get, especially in certain aspects of it. There's just no way he could. So, of course, Suckwitz is going to deny it. I would imagine any judge would have denied it. But at the same time, it did cause Suckwitz to say, "Hey, what about this surveillance?" And then that got, all that got put into motion. That's for another time. And then comparing that, and I don't know the process of how, if Avery or Zellner, when she came on board, if she could have amended his non-7406 motion. I don't know how that works, and I would be interested in knowing. It doesn't change anything. Just from my knowledge, I would like to understand that aspect. Moving forward, I'm not stopping until I'm forced to stop in this. I still think that there's a reasonable chance that the guys are going to get out, without a doubt.
Yeah, look, let's be open and honest here, right?
Yep.
Let's be open and honest here from a guiltist perspective. Is this the way to find the truth and seek justice? By legally blocking an attorney, an experienced attorney, from asking the hard questions? Is this what guiltists really want?
Yes.
To hide under the skirt of laws, Wisconsin laws. This is the guiltists are jumping up and down, clapping their hands. You got to realize that Kathleen Zellner has been on this rodeo many, many times, won cases harder than this. Is this really what the guiltists want? Or shouldn't the guiltists be saying, hey, the evidence against Stephen is so airtight, test what you want, he's going to be guilty of sin.
Thank you.
In fact, his own attorney said that to him. His own attorney said that to him. I find you guilty, Stephen. I'll let the world know.
I'm turning you in.
You could go back even further and ask them if this is the way they would have a case conducted against them, by having somebody that you're suing come and investigate your case to find you guilty. Would that be okay with them in the beginning? Not just everything that's happened since, but even that. I wouldn't want somebody I'm suing investigating any crime I'm accused of.
Right.
But the thing is, though, there is a special spotlight on this case. There has to be a reason why there is such a focus and spotlight on this case. And there's got to be one reason, and one reason only: Stephen Avery's civil suit that he put forward. Why? Because that civil suit would have opened the floodgates of everyone who was placed in prison using the Wisconsin State Crime Lab so-called experts. And all the police that put individuals in prison, all of their trials will be re-examined again, right? So you can remember about the those two lab techs.
Yeah.
That make all the results. 10,000 cases were thrown out.
How to fix a drug scandal.
10,000. The same thing would have happened in Wisconsin. They put a stop to it.
They had to. They knew they did. But
they shut the lid. They shut the lid, guys. They really did.
Yep. So, but I still think that moving forward, that there's other legal avenues that she'll take. Who knows what'll happen? I'm optimistic. It just makes me want to dig deeper, dig harder, and look further. And that's just me. I got convinced that, from an advocacy standpoint, that something needs to change. And I think that a lot of people now agree, Mann was biased. We all agree with that. That's the state's fault. They didn't want to participate. Hey, that's too damn bad. That's their problem, not ours. They decided that Ken Crest couldn't be in control of it, and he didn't want a part of it. But he didn't want anything memorialized that he might say on film. That's his problem. But I still think that due process was ignored. I think that they wanted that they had to end that lawsuit. because the depositions were going so terribly bad for them. They did not want that in open court. No way. No way. So if you haven't read the depositions, and they're floating around out there now, thanks to whoever, I would definitely dig in and read those and see what you see. It's interesting reading. And of all of the maneuverings that these state players did in order to keep and what they did in 85 and all the other things that led that were surrounding that. So anyway, before we jump off here, we've been pretty serious. I wanted to do this again to highlight what Avery did, how that process works. Zellner comes in, she files her own 97406 motion, and here we are. In addition to what we saw with the Court of Appeals and some of the things I saw there that piqued my interest a little bit. So I hope that was, I hope everyone kind of enjoyed that little trip down memory lane. And those that haven't read the 2013 motion, I would recommend just, reading it and see what he did and what he said at the time. That was 8 years ago now. So, but before we go, any other comments, anything going on anybody wants to plug?
Yeah. See what happens when I don't have my coffee?
I would just like to say that it's been a year now since Eric Cozy passed away, and just wanted to, let everybody know. We still have him in our thoughts, and maybe we'll just keep fighting for him too,
Absolutely. Yeah, I was going to mention him before we give an RIP Eric Cozy. I've actually put it in the description as well. I put a tagline.
I do want to mention.
And welcome Jeff Jones to who got the he was a winner of the advocacy program that they have from Eric Cozy. Jeff Jones is in our fall play, and he was a candidate and won. So congratulations to him too.
Congrats! Woo! Party.
Oh, very cool. Yeah. I do want to mention, we do welcome you guilters, but please, if you're going to come in here and you want to debate or argue, have a valid argument, an educated argument, please, because we welcome that. We do. But
Absolutely.
don't come in here act like an ass clown, because I will boot you.
Yep.
She has fun at that too.
Well, have your ducks in order. Be prepared for a real debate, not a bunch of name calling and just bullet points, blam blam blam. We want the full truth.
That's right. The important thing to realize is that we have gone way beyond MAM 1 and MAM 2.
Oh my gosh, yeah, way beyond.
We've gone way beyond MAM 1. MAM 1 and MAM 2 to me was just so I knew who the participants were. That's it. We dug deep into the trials, into the documents, right? We've come up to these conclusions after doing what? Several years of research. We don't throw away comments like the guilters do. They drop a grenade and run and think that they've achieved something. And that doesn't achieve anything. You've got to justify what you state, right? And Unfortunately, Stephen Avery had no choice but to go through the fact that he was framed. And so hence, it's very difficult to prove that you've been set up and framed, because you've got to point to somebody else. Otherwise, the law will reject it and make it very, very hard. And so, Stephen is in this terrible situation where he can't prove his innocence because they don't want the evidence to be retested again. So it's a terrible situation.
Well, I mean, we're faced right now with, trying to get the simplest of FOIA documents and so forth requested. If this case is airtight, what's the problem? Let's get it out there. Even as you can even look at the investigative arm of it, they kept investigating even after the trials were over. They were still investigating this case. It's in the case though. You can look at the documents. It's there. So if the case is done, why are you still investigating? We could even say that even further when, they reinvestigated in 2018. They're going around and re-interviewing all these people. So anyway, anybody else got anything before we get off here?
Want to plug something coming up
They
this week?
investigated even their star witness, Bobby Dassey.
Sure, they did. But they won't let go of that
Now,
November.
why would they do that?
They won't let go of that November 9 recording.
I know. Very, very interesting.
It is.
Yeah.
All right, folks. I hope everyone's enjoyed this lively debate today and the information. And who knows what we'll do next week on the open mic? Maybe we'll just do something really calm. I'm kidding. I'm just kidding. I really wanted to get this out, and hopefully we'll be seeing some new things very soon for us that we can discuss. As Linda said, our rest in peace, Eric Cozy. A lot of people, including myself, really became involved in watching his presentations, and he was totally convinced as well. You couldn't convince him otherwise. He was all about Brendan. He was all about Stephen, and some other cases too. So, and we miss his input and his laughter and everything else. Gone too soon. Anyway, this has been a Foul Play production.